Good morning. This is the New York City Board of Standards and Appeals Public Review Session for July 16, 2018. We'll begin with the special order calendar. Continued hearing items. Item number 1, 436-53BZ, 14150 Union Turnpike, Queens.
Fire department signed off on June 27th. The photo shows non-complying signs were removed, and the landscaping plan was provided, so I think that's the answer.
Item number, I'm sorry, go on?
Yeah.
Item number 2, 240-55BZ10, 20722 Northern Boulevard, Queens.
So this is a review of our November 21st, 17 decision to dismiss the application for failure to prosecute. It is not a rehearing, but additional materials were permitted to be submitted pursuant to a stipulation between the New York City Corporation Council and the applicant. The applicant submitted a letter stating that it had obtained support from residents who live opposite on 45th Road, and that the only opposition that they have is from one person who has appeared at the hearings on behalf of the Bayside Clear Spring Council, and the applicant argues that it's a one-person group, but we don't have any information on that one way or the other. I'd like to correct a few misstatements that were provided in the applicant's letter. First of all, this is a split lot, the Northern Boulevard fronting half being in a C2-2 R6B district, and the 45th Road fronting half of the lot is in an R4 district. The applicant's statement that there is no proposed use change, or that it is merely a change from non-conforming use group 16 automotive repair to conforming use group 9 auto sales, is incorrect as to the R4. And also, if auto sales are characterized as use group 16, then would be non-conforming as to the entire site. Any statements that may have been made to the community to this effect were misrepresentations. Notably, use group 9 allows for no vehicle preparation and no repairs, and I don't know if any of that occurs on this site, outside, inside or outside. The community board voted to approve the application conditionally. This has been repeated many times in this hearing, in the hearings about this application, and is the reason the board was so concerned about vehicular access to 45th Road. The applicant continues to misrepresent the content of the community board's recommendations. The conditions state that there be no road testing of vehicles on 45th Road, that the gate on 45th Road be locked at night after business hours, and that all lights in the parking lot be directed away from residences. The letter, the applicant's letter reiterates that the access to 45th Road will be used for test drives. This is directly contrary to the community board's conditional approval. Over the course of the 5 hearings this board held on the application, it learned that the owner of the subject lot is also the owner of the adjacent auto sales lots that occupy the entirety of the eastern half of the block, that's for Volkswagen and Mercedes, and that have open driveway access directly to Northern Boulevard. This understanding was reaffirmed in this recent submission. The stated reasons for the owner not using his own property to egress onto Northern Boulevard and away from 45th Road are convenience of business operations, and among them, brand separation. It adds, by way of threat to my reading, that if it doesn't use the curb cut from the subject lot to egress onto 45th Road, it will reopen other curb cuts onto 45th Road, all of which are associated with non-conforming uses as to the R4. And I'd like to know if that was how it was presented to the neighbors who occupy 10 of the buildings on 45th Road who submitted letters in support. If the other businesses that are owned by the subject owner don't need access to 45th Road for test drives, and those curb cuts have been, quote, voluntarily closed, then why does this business need such access? The materials provided for BZ 65-65BZ application, which is lot 29, were very instructive. The resolution and plans describe the site as being lot 29 as a standalone, a 25 by a 200 lot with frontage on both Northern Boulevard and 45th Road. The plans show the proposed building to be built 25 feet wide from side lot line to side lot line, making it impossible to exit the site except by driving through the building onto Northern Boulevard or out the rear open lot to 45th Road. In fact, however, Google Satellite shows that the rear open parking lot on Lot 29 opens up to the adjacent Lot 27, which appears to also have a curb cut to Northern Boulevard, although that curb cut was not indicated on the materials supplied to us. So that's a perfect example of one lot sharing the parking lot assets of the other. In fact, I count 3 open curb cuts onto Northern Boulevard, not one as shown on the materials. Furthermore, I fear, the building on Lot 29 appears to have been merged with the building on Lot 30, making it a combined zoning lot for which no amendment was filed at BSA. So I think, and then I open this to the other commissioners, unless the other commissioners feel differently and want to prolong this, we can have the applicant respond at the hearing to these and other comments and then close and vote on the merits of the application, so as not having more and more hearings. We've already had 5, this will be 6. Other comments?
I do want to say something on this, and that is, when I had voted against it, it was because additional documents were not submitted based on that. However, I think throughout the previous hearing, and I want to reiterate what I felt about the project, was that we need to keep in mind a couple of things about this site. One was that the prior BSA approval allowed for an auto body repair shop and use group 16B. It can continue to operate as that, but it's proposing to change to an use group that is much less onerous on the neighborhood. It is proposing a use group with use group 6, which is permitted along the Northern Boulevard, except that it's not permitted on the residential portion of the street. They had provided operational plans that we had asked them to provide, and one of the things was how the test drive was going to be done, and the test drive, how much was it going to use 45th Road. The applicant had said that they would exit from 45th Road, so because that is the easiest way and the quickest way to get to Clearview Expressway, and Clearview Expressway is where the test drive happens, and then they will return return back to the site. What I want to note is that there are a lot of other uses, auto-related, auto repair related, along that entire frontage. So it is not a primarily residential street. Whether through grandfathering or through special permits, we have allowed auto repair uses on one
Variances.
side. Variances. Auto repair and auto-related uses have been permitted on 45th Drive. And most of the businesses that are fronting 45th Drive have much bigger frontage, both on Northern Boulevard and on 45th Drive, than the subject lot. The subject lot has a total of 50-foot frontage on both on Northern, and so it is a lot more hemmed in its ability to use the frontage of Northern Boulevard both as a ingress and egress and customer check-in and other things, whereas the other lots are much bigger and they have the privilege of allowing for multiple operation happening at the same time without conflicting with each other. So I think we need to be cognizant of that, and as we received a letter that was sent by Mr. Henry Euler this morning on behalf of, I think it's Ms. Tashaka?
No, Mr. Shaka.
Mr. Chaka,
Yeah.
sorry. And Ms. Chaka said that there are other auto-related businesses that exist on the block and that are not accountable because they're grandfathered. And these are the uses that are actually primarily using the 45th Road more so than the subject site. There is a what is it?
Auto body.
There's an auto body, there's a huge auto dealership that's located there, and then there's a tile company. So they use 45th Road for their vehicular access and egress for delivery of their goods and parts from 45th Road, not Northern Boulevard. This particular use is going to have 4 to 5 at most, customers. Of those, it is anticipated, let's say the worst case, 5 of them will test drive in a day, as compared to all these other operations where the volumes of vehicles that they have on site is significantly more, and therefore are likely to have much more traffic, vehicular traffic going in and out of 45th Road. So I just want us to keep that in mind while we are considering this. And removing it from the 45th Road, answer is not putting it back on Northern Boulevard, because Northern Boulevard is a much more heavily trafficked road where turning movements and other things makes the traffic pattern much more complicated. And even if there was you were to allow vehicle enter into Northern Boulevard, it would have to make a left turn to go to another local residential street in order for it to get to Clearview Expressway. So we might be taking 4 or 5 vehicles out of the equation from 45th Road, a residential street, to another residential street where we'll be adding 4 or 5 vehicles into it, with the added traffic and turning movements that will be adding to Northern Boulevard. So I think with those in mind, I have always been not very comfortable with the idea of letting vehicles exit on Northern Boulevard, but letting them continue to operate on Northern Boulevard with some limitations on the hours of operations and hours of test drives.
Other comments?
I tend to be sympathetic to the applicant, and I agree with Vice Chair. She's made some good points.
Okay. Any other comments?
I take issue with the community board.
Can you speak up?
Sorry, I take issue with the community board not having the evidence properly before them. If they were told that the test drives are going to be on 45th Street,
No, they weren't told that they were. That was a condition of their approval.
Right.
That's what alerted us to this issue. And then there was testimony from 2 different neighborhood associations that reiterated that concern. That's why we focused on it so much. What I was referring to is that there was obviously outreach to the neighbors who are fronting on 45th Road that live across the street, because each of them signed a paper. So I assume they knocked on the door, or maybe there was a little meeting at somebody's house or something, and that there was a presentation made. And since there were statements made in the letter, I wanted to I'm querying whether that kind of statement was made to those residents, which misinformed them about the community board's action and misinformed them about the conformity of the use in the R4, which is not, right? Okay.
Item number 3, 2017-31BZ, 10717 34th Avenue, Queens.
Okay. As requested, a study of ownership of adjoining lots was conducted, and it appears that the subject site was held commonly with adjacent Lot 23 from 1991 to 1997. So the issue that needs to be addressed here isn't whether that formed a single zoning lot, because that's actually not the test, but whether the common ownership cured the hardship that's now complained of, and then its sale created it. So the applicant has to, I don't know if there's time for the applicant to address it in tomorrow's hearing. Normally, what we require is, would the combined site have been able to be, would it have been a viable site for development? Because actually, if the relationship between those 2 lots is quite odd. It's a kind of a long tail that has frontage, and then the other lot that's no longer part of this discussion is a rectangle above it. So it's not side by side making a perfect rectangle.
Right.
It's a rectangle with a tail of questionable utility. So that's the argument that needs to be made. Would the subject lot have been buildable had it been still part of that combined zone, that combined lot?
Sorry.
Also, and then they also provided a massing study, which is what we requested to show the building will be compatible with the neighborhood character. Anybody else on this? No?
Item number 4, I'm sorry, may I go on?
Yeah.
2017-39BZ, 271 Church Street, Manhattan.
They provided proof that notice of the hearing was posted in the lobby. Not sure that it gave the instructions to the neighbors to comment exactly, but we don't have anything from neighbors about this. This is the issue of whether it's an annoying use in the building. But we do have DOI, so I don't know that there's anything else. Neighbors didn't respond unless they come tomorrow. Okay.
New cases, item number 5, 933-28BZ, 125-24 Metropolitan Avenue, Queens. This case is being adjourned and it's being heard on, postponed until September.
Right, so I just want to say, though, this is a postponement request. This is the third postponement, as far as I can tell, or the
This is the
second.
fourth, actually.
Fourth?
I noted that this was also on the calendar April 10th. I don't know that it was in the, it's not in the lineup.
Oh, it wasn't in the lineup?
Yeah, so it's actually been postponed 3 times.
Yeah.
Previously.
Oh. Okay, so this will be the fourth?
This will be the fourth.
Okay, so no further postponements will be accepted, but we already sent them a certified letter on May 24th advising that this was the last postponement or the application will be dismissed. And so we can, therefore, at the next hearing, we can choose not to allow the extension and amendments, which will render the business illegal. So the owner needs to take this seriously, and I don't know whether we got a return receipt from the owner as opposed to council.
I believe we got it from council. We're still waiting for from the owner.
Say again?
We got the return receipt from the,
From Caliendo.
from council, but not yet from the owner. So it might.
Okay, so 524, that's almost 2 months that we didn't get anything. So I'm wondering
We could track it on, we could.
whether we can
track it
find
on-
another way of.
We can track it on UPS, we'll take a look in the.
Yeah, we
postal
can
thing.
track it.
Track it, yeah.
It's- Sometimes people don't retrieve those certified mails, right?
Yeah.
Intentionally. So if the owner's not notified, I'm wondering
But
another.
has council told us that they're not involved in this case anymore? Is there any reason to suspect they wouldn't tell the owner themselves?
She, the council said they know and they are responding to
Okay.
it. I mean, but I'll follow up with.
Yeah, but, this whole thing about tenuous relationships between their attorney and their client or former client, tricky, right? Because who knows
Yeah,
what communications
right.
are made, and this is too serious that the property owner we not know that the property owner was notified. So I'm just trying to think that we can discuss offline another way to notify the property owner, maybe FedEx or something like that, or a phone call, find it. Because it's a business, so, okay.
Item number 6, 13197BZ, 1600 Boston Road, the Bronx.
We have proof of notice of hearing to officials, but I actually didn't find proof of service of initial application to officials, and there's no community board recommendation. The flow of traffic, just going to the substance, the flow of traffic appears to be different than what was approved in the original application, so they need to provide a site traffic plan similar to what was provided with the 1998 drawings, and show there is adequate reservoir area for the 10 cars for queuing, which is required. They need to provide a lighting lumen spread diagram. They need to provide information on noise levels from the menu board to the property line, and to provide detailed landscaping plans showing types, numbers, and spacing of vegetation. And the site plan and other drawings should provide the same detailed information and notes as on the approved plan. This was a really abbreviated set that was submitted. It has to look like the approved set. It would replace it, right? It switches it out. So you have to have all the same information on those drawings, on the new drawings as on the old drawings. The drawing should indicate the location of all signage and provide calculations on the drawings themselves showing compliance with the C1 sign regulations. Photos show miscellaneous signage that's not shown on the plans. With respect to the 24-hour operation, signage, landscaping, and parking in defiance of the conditions of the variance, which apparently began immediately after the variance was granted. That's exactly the reason why a term needs to be retained. I'm totally against removing the term. In this case, the owners didn't even bother to come to renew for 15 years, so also ignored the 5-year term. So these are bad actors in the sense that the board grants a variance on condition with terms, and the owners ignore it completely. And also, we need to know what the neighbors think about the 24-hour operation and whether that's disturbing. They obviously weren't notified of the hearing, and they need to be, so there needs to be notification to immediate neighbors. There also isn't a permanent C of O, never was, because it's one thing if the C of O expires because of the term expiring, but they never got a permanent C of O. And the only thing I can say in its defense is the site looks clean. Others?
I had a question. The proposal is saying 8 parking spaces for reservoir. The previous plan showed required 9, whereas the resolution says 10. So it's kind of all over the place. I would like clarification.
Yeah.
I would think it should have been 10 because the zoning always required 10 reservoir spaces for the number of cars that is being proposed here. So I would like clarity on that, and there should therefore be, if it is 10, there should be 10 going forward also.
Yeah.
Also with regards to the change in the, you mentioned to the hours, they're proposing a change in the hour, and
They're proposing 24 hours as opposed to, I think it was midnight or something. Let's see, it was originally 7 to 11, or it was approved at 7 to 11, 7 a.m. to 11 p.m. Monday to Friday, and 7 a.m. to 12 a.m. Saturday, Sunday. That's a lot of hours,
right, but they're proposing the drive-through,
24 hours.
they're proposing a drive-through.
Yeah.
for
That's
us.
the issue.
24/7.
Right, they're
Okay.
proposing
I
24/7
misread
drive,
that.
right? It's not so much, it's not the restaurant, we're not even regulating the restaurant, it's the
I
drive-through.
misread it then.
Right, okay.
I will check into it.
They stated that the menu board is 23 feet from the adjoining property line, but I would like to know how far it is to the actual homes,
Okay.
because I believe there are 2 homes that actually line that lot line, that side lot line. And also on the signage analysis, they should break the signage out by frontage. And either count the banners and show it's complying, or get rid of all those
It won't be
banners.
compliant.
Yeah,
at
they
all.
need to get rid of.
Anybody else? No? Yeah, did you want to say
No,
something?
I just want to clarify that this was a variance for the eating and drinking establishment. This isn't an R district. It's
Yeah.
not a special permit.
Right, oh, okay,
So
yeah.
it is for the restaurant, is what?
I believe.
No,
I
no,
mean,
no,
just-
a restaurant was permitted, but not the
non-conforming?
drive-through, yeah. So
It's a
let's see, it was a
non-conforming.
1999 variance to replace an existing eating, drinking use group 6 with new eating, drinking use group 6 with drive-through and
So it was the
accessory.
drive-through that is, for which we
The
granted
variance
the
was
variance.
granted.
So we
It
need
was
to, so
non-conforming.
going back to the question of the maneuvering is critical to that effect, and so is the number of reservoir spaces.
But I would just double check because it sounds like the replacement of the eating and drinking establishment might have encompassed that this was a variance for the entire because you couldn't have
No,
removed the.
no, it was a non-conforming eating and drinking, so they could have put the eating and drinking back without any variance. That was my understanding, and we can check the
Yeah, just in
resolution.
case.
It wasn't that there was a prior variance that got amended, it was that they wanted to add the drive-through when they had the right to have an eating and drinking by grandfathering. That's my understanding, but we can check. Okay.
Item number 7, 30909BZ, 2173 65th Street, Brooklyn.
So I didn't find either proof of service of initial application or of notice of hearing to officials. This is both an extension of time to complete and an application to amend the variance, so notice is required. It'd be one thing if it was just an extension of time, right? The community board, though, did get something, so they must have had at least service of initial application. Community board recommends conditional approval, stating there be no commercial or community facility use at the subject site, and they oppose the waiver of parking requirements. So was already waived. There is a DOB denial for the side yard obstruction that's dated March 27, 18. I didn't understand what the need for getting that denial was. This is an extension and an amendment, and the amendment's unrelated to the side yard, unless the idea that you're increasing the height increases the degree of noncompliance in the side yard. Maybe that's why they did it. The application is due in part to the change in the zoning text that allows buildings to exceed 35 feet in height, as was the case at the time of the original approval. Interior layouts have been amended. The approved plans with 8 units had an elevator and a lift from grade to the first floor, which I believe is required by code. The proposed plans have no elevator, but do have 2 units accessible at grade. So they need to explain how this, or whether this complies with ADA requirements. There's a percentage that has to be accessible. And what about the other units? Because there is a percentage that needs to be accessible or adaptable. They need to show the height of the stair bulkhead. It's not dimensioned. The approved plans show a scissor stair for 2 means of egress. I don't find a second means of egress for this 8-unit multiple dwelling in the proposed drawings. The proposal is to eliminate the basement units, lift the first floor to grade, and increase overall building height to 37 foot 4 inches from 34 foot 8 inches. The floor-to-floor heights remain the same. The statement of facts incorrectly describes the proposed height of the building and the former height, so it needs to be corrected. In terms of the neighborhood context, I think the other proposal was a much better design fenestration-wise. It's just a nicer-looking building. But also because the bulkhead was on the side of the building adjacent to the 8-story apartment building that's next door. The proposed puts the bulkhead adjacent to the 2-story penthouses, so it makes it look even taller with respect to them. It's a less sort of polite approach to the very, very low neighbor against the much taller neighbor to the other side. And obviously, the board considered this sort of like a stepping up project where the height was okay because it stepped up to the much taller building. With respect to the implication of the B findings, which is just a question for Commissioner Otley Brown, does the removal of the elevator and the change from studios to 1-bedrooms implicate any of the findings? Of course, the only waiver is for this 8-foot side yard, the imposition of which would render a 16-foot wide out-to-out building. So maybe that's enough, but that's for you.
Actually, I actually asked the same question because the basement apartments go from being studios that are partially below grade to being 1-bedrooms at grade. So I thought that would implicate value, but the second level, it used to be the first floor, the studio becomes a 1-bedroom, however, then they're removing the balconies, which is taking away from value. So I don't think we need a full-blown financial, but I think it should still be addressed in a letter that basically shows the give and take. On the one hand, this may increase value, but on the other hand, the other part takes away from value, so therefore it's more or less a wash. I think that would be sufficient in this case.
Great. Any other comments on this?
No.
Okay.
Move on. Item number 8, 16612A, 638 East 11th Street, Manhattan, and item number 9, 10713A, 638 East 11th Street, Manhattan.
On June 19th, the board, on its own motion, decided to review its decision and correct the resolution to clarify for both DOB and the owner what we had intended them to do to move forward with curing errors on this project. The current C of O describes a 7-story building with 36 dwelling units. In the floor-by-floor listing, it states that there are medical offices in the cellar, first floor, and first floor mezzanine, and that there are apartments on the second to seventh floors duplexing to the seventh floor mezzanines, I think, because it's really unclear what that is. There is no mention of the fact that there is a structure in the rear yard that contains a cellar and first floor, and that is linked to the front building by a bridge. If an architect were trying to figure out where the medical offices were supposed to be, it wouldn't be able to figure it out from the C of O. As mentioned in prior hearings, we see Cs of O all the time that describe the other structure on the lot and its limitation on use. Some lots have two COs, one for the house and one for the garage. So step one, the resolution will be amended to direct DOB to modify or amend the C of O to describe a front 7-story building and a back 1-story plus cellar structure, specifically without mezzanine. The C of, because a mezzanine is not permitted as a permitted obstruction in any situation, right? The C of O will state the uses floor by floor in the 7-story building. It will also state specifically as to the rear structure that occupancy of that structure by ambulatory or diagnostic care facilities or residential use or any other uses not specifically permitted under the permitted obstructions regulations of section 23-44 or 24-33, effective as of the date of this resolution, are prohibited. Step 2. The resolution will clarify that the board has determined that as the 7-story front building was not affected by the text amendment to section zoning resolution 23-44 and was 100% complete to the board's knowledge prior to any other subsequent changes to the zoning text or maps that may have occurred, vesting the right to build the 7-story building was not at issue and not before the board. It will clarify that since only the first story and cellar rear structure, which began construction on foundations when section 2344 permitted obstructions in required rear yards to contain ambulatory and diagnostic care services, but did not complete construction until after the text was amended, needed to have vested in order to gain the right to obtain or retain a C of O, and that the board decided that pursuant to the test in Putnam, the right to that vesting was abandoned when the owner intentionally never occupied the structure with a use that conformed to the limitations on such permitted obstructions. Hence, the rear structure, as originally approved by DOB, is non-complying and should either be removed or made to comply with current zoning regulations. Step 3. The resolution will direct DOB to issue a permit to the 7-story front building to allow the owner to make the necessary changes to the front building to comply with egress requirements. 4, the resolution will also clarify that the BSA is not an enforcement agency and that DOB, equipped as it is with the power to issue violations, criminal summonses, and other aggressive but legal means, should use these means to require the owner to make these essential corrections. And I just think another note that I've discussed with council is this sort of debate about whether the permitted obstruction rule that says you can have a structure in the rear provided it is occupied by a particular use. DOB argues that is a bulk regulation and not a use regulation, and that makes no sense because the structure, as it stands now vacant, could be occupied by a house of worship and be complying, hence conforming. But the second you put a doctor's office in there, or sleeping accommodations in there, or an office building, an office in there, it becomes a non-complying, non-conforming condition. So the idea that there's no use regulation associated with that is absurd. And there are many, many sections in the zoning resolution where in the bulk regulations, there's a restriction on use. It's just the way it's written, and so we could actually find probably dozens of those examples, so DOB has that wrong. And we weren't asked to opine on that very specifically, but that's the pushback that we got over the course of this, their motions to re-argue and rehear, and so we'll also make mention of that in the resolution. And I don't know whether we'll have a draft of that.
The aim is to have a draft of that today.
Okay, so commissioners can look at the actual text to the extent that we can get it out really fast, right?
Yeah.
'Cause
Additional comments.
yeah.
I completely agree with the chair. The text, while it does allow for an encroachment in the rear yard of up to a height of 23 feet, it is a one-story, so therefore a mezzanine shall not be allowed. That's clear. It does also say, as per that amendment that happened back in 2004, that such beyond 100 feet, which this property subject site is, you could not have certain uses, and it only specified the uses that would be permitted.
Beyond 100 feet of the intersection.
Beyond the
of
100
street.
feet of the
Yeah.
intersection of the street. You could have school, it says, uses, community uses other than a school, house of worship, college, university, or hospital related. So those uses would be permitted. So while that bulk, if modified to a one-story below the height of 23 feet is done, then that bulk can be contained with a use that is permitted other than a medical office use. So it is up to DOB how it wants to retain that, whether it wants to retain the bulk or tear down the bulk or allow that bulk to be used by a conforming use. So I agree with the clarifications that's been proposed.
I agree.
Any other comments? An interesting,
Yeah, I'd like to add that, just for the matter to preserve the record, that Putman was cited in the applicant's original papers in the original proceedings.
yes.
One thing I did want to ask about was, sorry, thank you. This has been going on for a long time, this case, and whether there was any interest in the board in putting a timeline on compliance. And what the stick is, if,
Isn't that for DOB to determine?
It would be difficult with DOB. It would be difficult because the owner and DOB would have to be working together.
Yeah.
So it would be difficult to know who's using most of that time, whether it's the Department of Buildings not knowing, not moving quickly enough, or the owner.
I'm not sure why we would have to weigh in on the compliance. Is that what it was before us?
No, we were
doing
looking
an
an interpretation.
Right. So.
Or not an interpretation, this is a vesting application,
But
right?
we generally in the vesting, we do not put a time period on the compliance, do we?
No, so,
invested.
no, because they vested, what does happen sometimes,
true.
rarely,
Good
we
point.
had a case like that not too long, well, recently, where they vested the application like 15 years ago and then never built. And then we looked, then Putnam, the case, comes into play. What's going on here? And in that case, we decided after 2 extensions of time to complete, under the vesting, right? We just determined that they had abandoned under Putnam because they made no efforts, right? So we do look at that, and there is what is the time period? It's 4 years or something to complete under a vesting application.
Right.
Right, but this is saying, we're saying they vested but abandoned.
Yes, so here they
So-
abandoned,
They
Here,
vested the
so-
structure.
Right, but
But
abandoned the
abandoned
right
the-
to put the medical.
yes.
So I don't know that we can then have a timeline. What would the timeline be, that you have to rent to a school or one of
No,
the
this is
approved
only about the front
uses?
building, because one of the steps was, it was ordering DOB to issue the permits to correct the egress with the front building.
Right.
So,
Yeah.
say for instance, they just never go and get those permits, or they pull them, but they never construct. There could be
Oh,
a
okay,
situation
so
where
it's the
10
first
years from
building.
now, this building is still not complying with egress requirements. That's
Yeah.
the worry.
But my concern is it's really not our
It's
domain.
just a
I mean,
question.
and again, if only we had an enforcement wing, there's so many things we would do, but we don't have one, right? And DOB has many. And it seems to me that, they can even haul this owner into court, right? And enormous fines imposed. I don't know. I think there's even cases of owners who are scofflaws being imprisoned. So, they have way more clout in terms of this than we do. All we get to do is bring them in and argue with them in front of the public.
I agree with you.
Yeah, I agree.
Are we gonna leave the language regarding the vesting the same as it was before? In other words, I believe what we're saying in the resolution is they vested, but they abandoned the right to.
Correct.
In my opinion, they didn't vest, because in order, let's say somebody's coming to the board within 30 days, even within the 30-day time window, not after that. But in order to vest a case like that, within 30 days, the zoning resolution call for a condition that this construction should be lawful.
Should be what?
Lawful, legal.
Oh, lawful. Lawful,
Yes.
sorry.
So,
Yeah,
if you look, you have like one broad condition, the legality of the construction, and then other conditions related to the timeline. They have to put substantial portion of the foundation in order for them to vest.
Right.
My understanding, I wasn't present at the time we looked at this case originally, but my understanding is that, yes, they might have put the foundation in or substantial portion of the foundation in, but was that construction lawful or legal?
So
They-
just to kind of cut to that discussion, because we had it over, I forget the number of hearings that we had on this, but it could have been 10. DOB initially sent us, so we always rely on DOB's statement that the permit was lawfully issued.
Yeah.
When they say the permit was not lawfully issued, that's the end of our discussion, it didn't vest, right? But when DOB says it was lawfully issued, we rely on their permit. So interestingly, in this case, that determination by DOB flip-flopped. At the beginning, they said that the corrections that need to be made were so significant that the permit was not lawfully issued. Then, in the intervening hearings, there was a decision by a court that said that if it's correctable error, then the error is considered lawful, and as long as the error is correct. And the correctable error was in a case where foundations had been poured forward of the property line or something like that, and the only way to, or the setback line, and the only way to cure it was to build the building behind the foundation, and the court said, yeah, but the foundation isn't above the ground, it's not impeding on the setback requirement, therefore, easy enough, build it in the setback, curable error, right? So based on that direction from the court, the DOB retracted its statement and said that these were curable errors, therefore a lawfully issued permit, that we rely on that statement. So we don't look at ourselves whether the permit was lawfully issued. That's really DOB, or that's never before us in these applications.
This is not what I'm talking about. I'm not talking about the legality of the permit, whether the permit.
The construction was
Yes, the
legal.
construction.
They had met
They-
their
they did
thresholds.
not.
They had met their thresholds of substantial work and substantial money spent.
Right.
To
But,
vest.
and whether or not the work was legal, I frankly don't want to unpack that anymore, because we went through 11 hearings, and our engineer at the time reviewed those drawings, and DOB reviewed those kinds of questions. But I
There was
do
a
understand
determination
your.
that the construction is
Yeah.
legal and is.
Right. So I understand your
Okay.
comment. I don't think they ever ended up having to dig up anything to correct it because it was defective. That's not my understanding from the record.
No, or they changed something in the drawing, and I believe that's what they did.
But they're allowed to change the drawings, that's the other thing.
And the other thing is that since we had that important decision, it rendered just about every inconsistency with plans, with approved plans, as correctable.
Yes.
It really blew
Okay,
open the
okay.
door and made just about any error correctable.
Right, because you imagine, the foundations
Okay.
were poured and they're in the wrong place. That's correct.
Okay.
It is, you can dig again.
Right, and I think they shaved some of the exposed part of the foundation that was
Right.
above grade, they shaved it away, and so everything's on the table, basically
Right,
now, to be
right.
corrected.
Okay, I got it. Thank you.
Right, but thank you for that, that helps to clarify for everybody. Commissioner Shabeta, do you have any questions, comments? Okay.
Item number 10, 21013BZ, 4312 50th Street, Queens.
So we have proof of notice of hearing to officials. I didn't find proof of service of initial application to officials, though. This application was first filed February 1st, 2017, and received a dismissal warning. I'd like to know what the status now of the construction work. The compliance statement states that the signage does not comply with the C1 regulations. I don't understand why the corrective work isn't already done, given there's been over a year and a half to fix it, and it needs to be done now. They need to verify that the awning was removed and windows were tinted as requested by the board at the hearings for that variance. And I'd like to know what the status is on the installation of the fire safety measures that are shown on the plans. Fire department needs to inspect and comment on the application. I didn't see anything in the file on that. I also see that an alteration type 1 application for the required work was only filed on May 31st, 2018. So I don't understand the statement that work delays were due to, quote, dealings with contractors. Plans filed is not related to dealings with contractors. I also see a 2011 alteration type 1 application that was approved in 2014 for the same work, but no permits were ever obtained. I'd like an explanation on that, like what's really going on here. And that's just, it has to do with the reasons for the delay. Any other comments?
No, and I think we didn't receive, do we need a community board vote on this? No.
No, it's just an
Extension of time.
There's no notice.
But they did provide notice, so that's
It's
what
not
made it
required.
confused. Okay, no, no,
I
it's
see,
required.
okay.
I just had a question about the signage, because the previously approved plans had 2 non-illuminated signs that totaled 111.75 square feet, and the new signage analysis says that there's 72.50 square feet total and non-illuminated, and so are they reducing the signage to 72.5? Is the question, because if the 111 was on the previously approved plans, isn't that approved, and couldn't they just stay with the 111? And do they have more than 111 now, and is that why they're reducing? That's my question.
Okay, anybody else?
Appeals calendar, decision items, item number 11, 2017-232A, 1632 Richmond Terrace, Staten Island.
Notes were added to the drawings as requested, but I didn't find one stating that the building will be fully sprinklered or Siamese connections to remain unobstructed, or a note about a sign indicating location of the Siamese connection. These are all notations from the fire department. Maybe they're on there. It's a very wordy set of plans. There's lots and lots of words all over the place, and maybe it's there, but I couldn't find it. I would like the fire department to review the drawing and make sure they're okay with it, because if they're okay with it, okay. Because it's really a fire department condition. Okay, anybody else?
All right. Item number 12, 2017-234A, 266 Wild Avenue, Staten Island.
Corrections were made to the plans, and the fire department should review to be sure they're okay with them.
Okay,
Um,
so, I'm sorry.
Yeah, let me just finish this thing. So, and with respect to DOT sign off, I wrote DEP, but I meant DOT, we're trying to clarify, and maybe we got some additional information from the borough president.
Which I sent to the DEP.
You sent to DEP?
Right, this is
Okay.
DEP.
It's DEP, not DOT, sorry. DEP has been upset about not having a copy of the official map. It turns out there kind of isn't one, so maybe there's more information.
Well, I sent them what the borough president's office had sent us, but I haven't heard anything back, so I'll reach out to
Okay.
them again today.
Yeah,
Also-
so, go ahead.
Okay. Also, this morning, I received from the fire department, they want corrections to the plans. They had a marked-up version, which I forwarded to all the commissioners
All right.
this morning. They had some questions on the plans, whether there's some notations about the street, the status of the street, talking about the width of substandard width of one of the streets, and there was a mistake on where the main front entrance requires 30 by 30 frontage. There's a few notes on here, and I forwarded that to the applicant, and then the applicant this morning submitted a corrected plan with some comments, so hopefully that'll satisfy the fire department.
Okay.
This
so-
just happened this morning, so it's like.
All right, so we have both of these things where it's a mystery to us what exactly it is DEP wants. It's a mystery to the applicant as well.
And the fire department wants corrections on the plan, so
Yeah,
I guess we have to
so
reopen
hope-
this or defer, I don't
Yeah.
know. Hopefully it'll get cleaned up by tomorrow.
Right.
Item number 13, 2017-285A, 200 Amsterdam Avenue.
I recuse from this.
Okay. Yep. So, the appellant, owner, and DOB, they have all submitted responses to the questions raised at the June 5th hearing. To date, we have received very thorough, detailed analysis from DOB, the owner, and the appellant for our consideration. But we are only faced with the following two questions. Board will only consider whether, at the time the permit was issued, one, DOB's interpretation that the subject zoning lot meets the definition of a zoning lot in section 1210D of the zoning resolution is supported by the text and therefore reasonable. Second, DOB's interpretation that the subject zoning lot complies with applicable open space requirements is supported by the text and therefore reasonable. What I'll do is I'll start with the easy one, which is the open space. Based on the documents provided, we need to determine if the required open space on the subject zoning lot meets the 1210 definition of open space. Appellant states that the phrase quote-unquote accessible and usable by is not defined in the zoning resolution. And appellant further states that in the absence of the definition, we should consider the status we should consider the statute, and that to determine the meaning, we must look to other provisions in the zoning resolution relating to such as large-scale developments and special districts. If we were to look to other sections of the zoning resolution to determine a meaning as deemed appropriate for a specific development, we would be misapplying the zoning resolution. Open space is a clearly defined term, so we do not need to look beyond the definition. Furthermore, DOB has determined that the open space on the subject lot is complying with the zoning resolution and that the open space provided is open and accessible. Appellant has raised specific concerns with regards to existing parking space located in a portion of required open space on the proposed development site being counted towards open space. DOB has determined the legal status of the accessory parking for 170 West End Avenue located in the proposed open space serving the proposed development at 200 Amsterdam Avenue. It has been determined that the 26 accessory parking spaces was lawfully established per 1916 zoning resolution, and these are legally accessory use and is a permitted obstruction in a required open space per 23-12 section of the zoning resolution. So based on the definition, the open space, I believe the open space is complying. And any further business terms between the 170 West End Avenue and 200 Amsterdam Avenue is not in our purview for our review. So now let me go to the zoning lot issue. Based on the arguments presented, we need to determine if the subject zoning lot meets the 1210D definition of a zoning lot. As we know, 1210D subpara was introduced in 1977, and it allowed for multiple ownership of a zoning lot. Appellant's position is that the subject zoning lot does not meet the D definition because, quote-unquote, lot of record, though not a defined term, is the same as a complete tax lot. the appellant states that the subject zoning lot includes partial tax lots, which is not permitted per 1210 definition. Thus far, appellant has not provided any clear evidence that the text is meant to be interpreted in the manner in which they suggest, other than a draft bulletin by DOB. DOB issued the subject permit in accordance with its 40-year-old interpretation set forth in the Minkin memo that zoning lot can consist of partial tax lots. DOB states that it is considering changing this interpretation, but I note that the memo setting forth the new interpretation is still in draft form and that DOB has not rescinded the Minkin memo. Finally, the owner states that the subject zoning lot is an existing validly formed unsubdivided tract of land declared to be a single and separate zoning lot with multiple owners pursuant to the subpara D definition of zoning lot. I note that the subject zoning lot was originally formed consisting of partial tax lots in 1987. The owner also states that the subject zoning lot in the alternative could be a tract of land consisting of 2 or more lots of record contiguous for a minimum of 10 linear feet located within a single block, since the zoning lot consists of 2 whole tax lots and 4 partial tax lots, each under different ownership. As we consider the definition of zoning lot, we need to keep in mind that a zoning lot is a planning tool regulated by the zoning resolution that shapes the development or developments on a zoning lot by regulating density, the massing of the buildings, the location of these buildings in relation to each other, as well as lot lines, open space, parking, etc. The zoning resolution requires a meets and bounds description of every zoning lot to be recorded, whether it existed prior to December 15, 1961 or after, and regardless of ownership, as per the last paragraph of 1210 definition, which applies to all 4 subparas A through D and specifies the process of the zoning lot, recording of a zoning lot. Specifically, it says, I quote, "Prior to the issuance of any permit for a development or enlargement pursuant to this resolution, a complete meets and bounds of the zoning lot, the tax lot numbers, the block numbers, and the ownership of zoning lot as set forth in paragraphs A, B, C, and D herein shall be recorded by the applicant in the conveyance section of the Office of the City Registrar," and in bracket, "or if applicable, the county clerk's office," close a bracket, "of the county in which the said zoning lot is located." Thus, the act of recording a zoning lot requires meets and bounds, tax lot, block, ownership. Describing the meets and bounds of the tract of land being used for development or enlargement specifies how zoning regulations will apply to that tract of land, which cannot overlap with any other tract of land being used for development or enlargement. This meets and bounds description, which encompasses the entire land parcel, accordingly specifies that exact lot, quote, the parcel of land or quote unquote tract of land being used for development. Recording all these instruments makes the lot or a tract of land or a lot of record or even unsubdivided tract of land. The zoning resolution does not require the meets and bounds to be coterminous with a tax lot. The 1210 definition even does not require a zoning lot to coincide with a lot as shown on the official tax map or any recorded subdivision plat or deed. The meets and bounds of a zoning lot description is recorded against all of the affected tax lots, whether they are wholly included within the bounds of the zoning lot or not. Like an easement that traverses across a small sliver of several tax lots is recorded against all the affected tax lots. While I agree with DOB that private documents such as deeds, mortgages, and private development agreements are recorded and that they are recorded against tax lot, that does not necessarily mean that zoning lots must contain entire tax lots. A tax lot is a tool used by the city for recordation of taxes, assessment, ownership purposes. It is also a unit against which zoning lot can be recorded, but it is not element upon which zoning lot, which again are defined for development purposes, are defined. The appellant has not referred us to any authorities for the technical or exact meaning of the word lots as used in the definition of zoning lot. Based on my experience and an examination of all the materials submitted on this application, I am of the opinion that the meaning of the word relies on the context and the circumstances under which it is used. The zoning resolution as it is written today does not state that a lot of record is only equal to one entire tax lot, and neither the appellant nor DOB have been able to provide convincing evidence that the drafters of the 1977 text amendment intended for lot of record to mean one thing only, a single tax lot. The thinking behind the 1977 zoning text amendment to the 1210 definition is clear from the City Planning Commission report for the 1977 text amendment, City Planning Commission report number N760226ZRY. The 1977 City Planning Commission report used the term quote-unquote parcel as all throughout the report, not tax lot and not even lot of record. The report states, I quote, "The proposal provides that a single zoning lot can be created from adjacent, differently held parcels through the filing and recording of a declaration of single zoning lot status executed by all parties having defined interest in the parcels in question." The report referred to tax lot only in terms of recordation, not as a term intended to serve as a substitute for the phrase lot of record. And again, I quote, "Such recording to be against each tax lot constituting a portion of the land covered by such declaration and to be in the office of the city registrar or, if applicable, the county clerk's office of the county in which the parcels are located." The zoning text and the 1977 CPC report for amendment to the 1210 definition of the zoning lot make evidently clear to me that a lot of record is not solely equal to a whole tax lot. Instead, I believe that a lot of record is a described and recorded parcel of land which may include land covered by one or more tax lot or even partial tax lots. With regards to Commissioner Shedder's comment at the last hearing that per subpara D, a tract of land must be either unsubdivided or two or more lots of record, and that a literal reading of that text means that one tax lot plus one half of an adjacent tax lot cannot constitute a zoning lot, but two tax lots plus one half of adjacent tax lot can constitute a zoning lot. I would like to point out that even in assembling one tax lot plus a portion of an adjacent tax lot to create a zoning lot, one is dealing with at least two lots of records. Furthermore, I believe that if the drafters of the zoning resolution wanted to prohibit the inclusion of partial tax lots in the zoning lot, it would have been explicit in the text, which it is not, or it would have been discussed in the 1977 City Planning Commission report, which was also silent on this point. The 1977 amendment was adopted to bring clarity to the ownership requirements necessary under subpara C per the 1961 zoning resolution. Throughout the 1977 CPC report emphasizes the previous text's lack of notification and recognition of leaseholders as ownerships sufficient to form a zoning lot as the reason for the amendment. The report did not at all identify partial tax lot as an issue to be addressed by the text amendment. DOB's interpretation of the City Planning Commission report is, I believe, flawed when it states that when, and I quote DOB's statement from the June submission, when the focus became noticed due to the ability to form zoning lots with multiple parties in interest, newly formed zoning lots could no longer contain partial tax lots, since that would be harder for future future interest holders to follow. DOB was not clear in its statement as to how it would become harder for future interest holders to follow. If zoning lot was permitted to include partial tax lots, since pursuant to the last paragraph of 1210D definition of zoning lots formed consistent with subparas A, B, C, or D are required to be recorded. If, for example, a property owner sells a rear 10-foot deep portion of its tax lot to allow for the transfer of unused floor area from the parcel to the west of it to the parcel to the east of it, the deeded 10 linear feet is recorded against the property owner's tax lot and included in the recording of the new zoning lot via a description of the new zoning lot's meets and bounds, and this meets and bounds will not be coterminous with any other meets and bounds. I do not understand how prohibiting the inclusion of partial tax lots in the zoning lot, as DOB suggested, was done and is necessary where CPC has introduced a recording requirement. While I agree that the 1977 amendment to the zoning lot was intended to bring clarity and transparency to the zoning lot formation process, it aimed to do so only by clarifying that a leaseholder does not have rights tantamount to ownership and adding a requirement that the meets and bounds of zoning lots, among other things, be recorded in the Office of City Registrar, a requirement that was omitted from the 1961 version of the definition. Zoning resolution definition of zoning lot has allowed for flexibility in forming a development parcel from its inception in 1961, and it was not curtailed in 1977 amendment. This is evident from the fact that there are 4 available ways in which to qualify as a zoning lot, and while a zoning lot may meet one or more of those definitions, it is the option that best serves the property owner that is generally applied. Zoning lot subpara C and D allows 2 or more lots of records to be contiguous for a minimum of 10 linear feet, when we typically have seen lots in New York City to be 20 by 100. The intent of this flexibility was to allow for floor area to be allocated to where it makes the most sense. By requiring a 10 feet of contiguity, the 1977 zoning lot text amendment allowed for the provision of partial lots or creation of 10-foot wide contiguous tax lots. The text used tract of land, which was introduced in 1961, and not tax lot, to allow for flexibility in forming a zoning lot for development, provided that all development within the zoning lot is compliant with applicable bulk regulations, and zoning lot is declared and recorded against all affected tax lot with the zoning lot meets and bounds. So based on the review that I read out, all of the materials submitted, and keeping in mind the purpose of the zoning lot, which is to ensure that developments and enlargements comply with applicable bulk regulations of the zoning resolution, I remain firmly convinced that the inclusion of partial tax lots and in a zoning lot was not prohibited, and that lot of record is not always the same as tax lot. So with that.
Okay, I just want to say that I have not changed my position from the beginning. I'm in agreement with the appellant's position that the gerrymandered zoning lot was not properly formed as per ZR 1210 definition of a zoning lot. Subsection D, because it contains partial tax lots which are not lots of record when you're referring to the official tax map of the City of New York, because that does not include partial tax lots. So I diverge from that baseline point, and so therefore I disagree with everything else that you've said.
What about the open space?
As to the open space, I also did not deviate from my previous position that I felt that the open space requirements were satisfied.
Open space requirements were satisfied.
They meet the zoning regulation.
Right. I don't have an objection to that determination.
Okay, so I start like Vice Chair did with the open space. I agree that the open space is a well-defined term in the zoning resolution, and we don't have to like dig or reinvent the definition for that. And I believe the the status of the open space is satisfactory. The open space is okay, and consequently, the parking part is okay. With respect to the other challenging portion of the appeal, I did read through the zoning resolution A, B, C, D of 1012, probably like 50 times so far. And I'm still convinced that based on the sequence of the items and the way they were changed from the 1966 to 1977, I believe partial lot of records should not be included in a zoning lot. But I repeat it again, partial lot of records. I look at, the way I look at this, it's like calculus. I'm an engineer, so forgive me for that. I look at it like it's a calculus problem. So then, if partial lot of record cannot be included, the other issue is a lot of record equivalent to a tax lot? I believe, based on what I read so far, I believe tax lot is definitely a lot of record. But the opposite is not necessarily true. Lot of record can or cannot be a tax lot. So the problem here is, can we take the word lot of record and replace it with tax lot? Again, is X equal Y? That's how engineers think again. In my opinion, I don't think so. I don't believe that we can, like I said, if I have tax lot, I could just strike this, put lot of record, very satisfied about that. But if I have lot of record, I cannot do it. It's not necessarily, it's not all the time, could be replaced by tax lot. So my position so far, and hopefully it's not gonna change, is that the claim that the zoning block, the subject zoning block, cannot be considered legit. I disagree with that claim, and I believe the subject zoning block, based on the definition of the zoning resolution, is okay.
Okay.
I agree with the Vice Chair that the easy question here is whether the project complies with open space requirements, which I believe the project does. The harder question before us is was the Department of Buildings' interpretation of the zoning resolution a reasonable interpretation? I believe it was. This interpretation that was implemented on this property for 40 years on the basis of the 4 buildings surrounding the subject development and relied upon by the owner was repeatedly submitted plans and redrawings to the DOB cannot be so easily deemed unreasonable. DOB may decide to change their interpretation in the future, and while it can be argued that a lot of record is a tax lot as opposed to what is recorded in the city register or county clerk, that does not mean that not taking the most restrictive definition is unreasonable, nor does it mean that the argument is entirely compelling. Not to mention the possible constitutional issues which such an interpretation can create, as property rights are in essence personal ones. And without having a specified procedure in the text itself, it does leave this complex issue open. But again, that is not before us. In any event, this would have only been one hurdle, while the second would be the assumption that because a zoning resolution does not specifically mention partial lots, then they must be implicitly excluded, as the zoning resolution refers only to full integers. I'm not compelled by the Department of Buildings' position that a lot of record can only be a complete tax lot, because the declaration of restriction can only be filed on tax lots. As in the case before us, a declaration of restriction was filed on each of the tax lots in question. While I'm not taking a position on such an interpretation or application, as no such question is before us, I simply cannot agree that DOB's interpretation that is practiced citywide and at this specific location for 40 years is an unreasonable one. It is evident by the divide of this board and the unsettled position of the Department of Buildings, that with regard to partial lots, the language is ambiguous. And as such, a Court of Appeals precedent established in Matter v. Allen v. Adami and upheld in Toys R Us v. Silva, that any ambiguity in language used in such regulations, such as the kind that exists here, must be resolved in favor of the property owner. We must be honest with ourselves. My colleagues are learned individuals, some of which have wrestled with this interpretation for nearly 4 months at a time, at times taking the position of the appellant and at others position of the owner. The current highest-ranking officers of the DOB are still uncertain whether they agree or disagree with the former highest-ranking officers of the Department of Buildings that held firm to an interpretation for at least 40 years, coupled with the fact that some of the members of this board, after studying the hundreds of pages of material over countless hours, have wavered. How is it that we can say that this language is not ambiguous? Finally, we've had 2 full hearing days where the applicant and others pointed at this property and stated the evils of partial lots in this case. Yet what remains uncontroverted is the owner's position that had these lots been merged or otherwise full tax lots, the building would have been substantially the same and, more importantly, the same height. To now rule where the owner relied to what could now be his detriment on DOB's reasonable interpretation and did not see the need to merge the tax lots because no such issue ever arose in the history of this property, that now the permit should now be revoked seems arbitrary and capricious.
Can I just raise a question? I'm not sure that the appeal was whether or not DOB had a reasonable interpretation. I think the appeal is based on the validity or invalidity of the permit. So shouldn't...
But the 2 reasons that the appellant proposes that the permit was not valid, the issue is because the zoning lot wasn't properly formed.
Right.
Didn't comply with open space.
Right, but does that really have anything to do with reasonable? I mean, I think that going into this, the definition of reasonable, yes, I think that all of the official players here made reasonable interpretations, but the question is it valid? That's different from the word reasonable. Reasonable means well-reasoned. You know, it means it was a very thoughtful approach. I think it's a given that the officials made thoughtful interpretations of what they read. The question is, was it validly formed? I don't know if that's the same question that we're deciding on as whether it was well-reasoned.
So posing the question to Commissioner Trevino.
Yes,
Yes,
so-
so would you say that this interpretation of DOB, that the subject zoning law complied with subparagraph D's definition of zoning law, is that a valid interpretation of the ambiguous language that you've identified in subparagraph D?
So I would say it's...
Okay.
That's
that
all.
clarified?
Yeah, I felt it
Okay.
should be clarified for the purposes of the resolution.
Thank you, I agree, yes, appreciate it. Any other comments? Great, okay. I'll bring it.
May I call the next case? Mm-hmm. Continued hearing items, item number 14, 257-15A, 1221 Forest Hill Road, Staten Island. It's been administratively adjourned.
Right, so I wanted to add, though, this is another one of these problematic applications, since it was submitted in November of 2015, with dismissal warning of January 2017. At the last hearing on May 15th of this year, we questioned whether this is properly before us, since it is apparently an effort to use the GCL waiver to bypass zoning, since the imposition on the map street is only 1 inch. So we should, again, send a certified letter to the owner, so that's our council sends a certified letter to the owner and applicant that there will be no further adjournments, and the board will render its decision at the next hearing.
Item number 15, 2017-5A through 2017-7A, 620A, 620B, 620C, Sharretts Road, Staten Island. It's administratively adjourned.
Also,
Item number 16, 2017-193 to 199A, 9, 10, 11, 12, 14, 15, 17, Tupelo Court, Staten Island. It's a GCL 36.
Right. So we have a new letter of opposition concerning DEC review of the wetlands. We've discussed this subject at length at prior hearings. We now have several sets of drawings, all of which will have to be incorporated into the approved set, since there is different information on each one. I wish the applicant, please, would take the time to ensure coordination among the drawings, to ensure that they all convey the same information and submit all the latest versions of the drawings as a set at one time. So in trolling through the file, which was the only way I could figure out what drawings we have, there's a BSA 1 through 3 that was submitted on September 11, 2017. There's something entitled Internal Roadway, Sheet 1 of 1, that was submitted June 27th, 2018, and I can't find a builder's pavement plan that looks like either of those. Because one of the things that we were asking for was that the sidewalks that are running along the Map Street join up with Tupelo, right? And so that needs to be shown on the builder's pavement plan and doesn't. So I understand that there's such a thing as a private versus a public builder's pavement plan, but we don't have the public one that shows it joining up with Tupelo. So maybe something's missing from the file. I really did have to open all the folders looking around for drawings because the applicant really didn't give us a cohesive, coherent set. And I wish they would do that because that's what their job is, right? Any other comments? Yeah, go ahead, speak up though, please.
So the problem I have with approving this is that the future owners in the community do not have the same safeguards as they would have if this was a mapping action. There's not a single owner with 1 or 2 houses on a lot who needs access to a street. This is a substantial development that is further complicated by its location. We simply do not have the resources to take into consideration everything a mapping action would take into consideration, nor should we. Because the considerations mentioned in the language of the GCL are extremely limited, limited to not much more than the board may make any reasonable exception and issue the certificate of occupancy subject to conditions that will protect any future street or highway layout. It does not mention drainage, maintenance, connection to sewer lines, garbage, or anything else DEP or DOT consider in a mapping action. Developers may like you to believe that the legislator intended the GCL 36 to be a free pass to any owner regardless of development size or the complications created by wetlands, etc. The legislation did not intend the GCL 36 as a way to circumvent the necessary considerations of a mapping action, nor does anything in GCL 36 suggest that the legislature intended the BSA to take on the role of the City Planning Commission and conduct its own streamlined mapping action, otherwise we'd have the resources to do so. There can be no dispute that developments such as this one require consideration greater than just the protection of any future streets. That is just common sense, and the zoning resolution details the considerations that are necessary with developments like this one, all of which legislature has passed in a mapping action. Moreover, the statute specifically states that before the BSA can grant any such waiver, the applicant must show practical difficulty or necessary hardship, a factor it has failed to do so. And considering the size and profit of this type of development, I don't believe it could possibly make such a showing. Finally, in a mapping action, there's a mapping contract. There's a mechanism holding the developer responsible for the project. We simply don't have that level of enforcement. Prior to my time, the board has approved the building of these units, and I commend the board on the safeguards it put in place. I do not believe we are the appropriate or legislatively intended agency for these types of developments. And as such, I have to vote against this waiver, hoping that my colleagues will join me. Finally, the fact that we've done something a certain way and approved these waivers in a ministerial manner in the past is not support for us continuing this practice. Such a process is an affront to the good people of the city. And as a lawyer, I assure you, the decision continuing down a path only because that is what we've done before while ignoring all the new concerns and dangers is not only in fact arbitrary and capricious, but it directly contradicts our charter.
Okay, any other comments? No? Okay, thank you.
Move on? Item number 17, 2017-282A, 148 Sprague Avenue, Staten Island. It's an adjournment, and they've asked for a short adjournment, Veronica?
Yeah. Because they already made their submission, it was just late. That's my understanding, right?
Yeah, it was on time.
He's not
Oh,
available.
no, I see, that's right, sorry. He
he's
just
assigned
couldn't
a short
appear.
adjournment.
Yeah, right. That's a requested adjournment, okay.
Item number 18, new cases. Item number 18, 2017-290A, 1558 Third Avenue, Manhattan. This is an interpretive appeal.
Right, so I'm going to read my comments, which are really, really long, because I do have to admit that a lot of this was thinking out loud as trying to get my head around some of the questions before us, or even all of the questions before us. So the questions before us: if two tracts of land consisting of two or more lots of record are under single fee ownership, and with respect to each party having any interest therein is a party in interest, is it a single zoning lot under the 12-10C definition in spite of an effort by a property owner to subdivide it by a recorded subdivision instrument? That's the main question. And so some of my responses are questions that I would like both sides to respond to. What if the parties in interest are different LLCs with the same managing members, is another question. DOB's September 28th, 2017 denial of appellant's challenge to this question imports the C definition imports into the C definition a requirement to, quote, declare the tracts of land as a single zoning lot. Such a declaration requirement appears in the D definition, not in C. C requires no further efforts than common fee ownership and filing a building permit. But the C definition forms the zoning lot at the time of filing for the building permit, and a building permit clearly is only applied for after the new building application is approved, or an alteration type 1 where that's relevant. Here, in this instance, a permit issued in July 2015, so the relevant zoning lot information under the C definition are the plans approved in 2015. However, because the zoning lot includes development rights parcels, the zoning lot's expansion had to include a D formation. A D formation is the one that requires a declaration of zoning lot restrictions declaring this to be a zoning lot, although not at all with respect to the lots held in common ownership prior to that merger with the development rights parcel, Lot 32. In fact, that merger occurred when Lot 37 was only 20 by 78 dimension, pursuant to a development rights transfer, zoning lot development agreement, and declaration of zoning lot restrictions. So this was a very typically formed development site. This is actually one of my specialties when I was working in the private sector. This was a very typically formed development site where development rights were acquired through a contract, the zoning lot development agreement, and the contract isn't necessarily recorded yet because that's not required. The transaction goes on behind the scenes. And then the development rights are transferred by a declaration of zoning lot restrictions to the adjoining tax lot, which is not the full development site. That's also very typical, where you just transfer it to kind of what you've got now. And then further acquisitions or further mergers move the development rights onto the entire development site, or conceptually move them, even though, of course, nothing moves really anywhere. Nonetheless, whether or not a C lot has been formed does not prevent the C lot being the one where you file a permit and you state that this is a zoning lot because you're the owner of record of all of the tax lots in the zoning lot. So whether or not a C lot has been formed does not prevent a later subdivision, provided the subdivision complies with the zoning resolution. Appellants keep focusing on ownership as if the common ownership cements the zoning lot permanently, but zoning lots are subdivided by zoning lot owners whether or not they own the entirety of tax lots of a tax lot or lots on the zoning lot. There's no other way to accomplish that. That's extremely typical. As to Department of Buildings assertions that all of the parties in interest to Lot 138 and 37 are not the same parties in interest since it's held by different LLCs, that is where I disagree. When the method for creating other parties is an operation of LLC disguised straw men, where the managing members and addresses are all the same. To view it otherwise is naive and doesn't reflect the reality of New York City real estate transactions. Everyone owns a piece of property as an LLC. People buy houses as LLCs now. So to say that it's my house and my house next door, or my house and the lot next door under two separate LLCs, sometimes for whatever tax purposes, right? Or liability purposes. The Department of Buildings states in their June 26, 2018 submission that there never was a subdivision of a zoning lot. I really believe this is incorrect. Former Lot 140 was a separate zoning lot with an existing building, which was later demolished. By July 22, 2014, Lot 140 and former Lot 38 were merged into a single tax lot 38. By November 25, 2014, the 4 by 22 88th Street lot had been severed from Lot 38 and assigned tax number, lot number 138. A zoning lot description and ownership statement and a certification of parties in interest were recorded on December 20th, 2014, stating that new Lot 38 and new Lot 138 were a single zoning lot, both parcels owned by 180 East 88th Street Realty LLC and subject to the same M&T Bank mortgage. Hence, all of the parties in interest were the same. I'd like to know whether DOB is now saying that this very standard operation by a property owner prior to applying for an NB or alteration application and required by DOB prior to doing so does not form a zoning lot. This is the statement, the zoning lot, the owner's statement that this is one zoning lot. That's all that's required by DOB, but DOB requires it of everyone filing an application to build a building or alter a building. On February 25th, 2015, a new zoning lot description and ownership statement and a certification of parties in interest was recorded against Lot 38, which excluded Lot 138. That was a zoning lot subdivision. And owner's submission includes the Department of Buildings July 31, 2015 subdivision approval in its papers, Exhibit 5. The owner didn't provide a copy of the plans that were submitted with that application and should have done, because there should be a diagram that describes that subdivision. On the same day, that's February 25th, 2015, a declaration of zoning lot restrictions, zoning lot description and ownership statement, and a certification of parties in interest were recorded to merge lots 37, 38, and the development rights parcel, lot 32, into a single zoning lot. The certification of parties in interest included waivers of declaration from all parties in interest. Nonetheless, DOB states that the merger was ineffective. I don't understand how that could be. If, as DOB states, there is no minimum requirement for a zoning lot, what did it matter whether the lot was 4 feet deep or 10 feet deep? In any event, the creation of Lot 138 was a subdivision from original Lot 140 or from new Lot 38. By March 25th, 2015, new tax Lot 38 had been merged with former tax Lot 37, and on May 24th, 2017, Lot 37 and 138 took on their current configuration by terminating the declaration of zoning lot restrictions and recording a new declaration. I ask of DOB, why wasn't a subdivision required instead? And I'd like to ask, under what conditions can the formation of a D zoning lot be terminated, therefore obviating the need for a formal subdivision? The DOB draft bulletin suggests that a zoning lot D formation can be voided prior to permit. My understanding, and this is left over from my days as a transactional lawyer in this discussion, is that in the transactional world, this back-out option would make lenders and investors very nervous, their underwriting assumptions relying as they would on the zoning lot described in a host of deal documents. So the idea that you tell the lender that we're buying the development rights from all of these lots, or I'm merging with one of these lots to make the development site larger, and then just prior to permit, so they commit to the loan and they fund, right? And then you back out just prior to permit, I find very bizarre and not at all what the zoning resolution states. Zoning resolution states that the zoning lot is formed at the time of the recording of the declaration of zoning lot restriction. I actually find DOB's objection about the depth of the zoning lot bizarre, since contiguity, and the definition requires 10-foot contiguity, is not the same as depth, and I dare say that there have been zoning lot mergers with shallower than 10-foot morsels connecting one lot to the other. The owner provided a copy of a DOB 2014 ZD1 approval requesting confirmation of the permissibility of an identical subdivision in Queens. The purpose of that subdivision isn't clear from the submission, and the subdivision was never done according to current Department of Finance, ACRIS, and DOB records. So just as an example, but DOB did approve one. The other site included by owner for an example of a recent sliver lot subdivision on West 27th Street is described only by its recorded zoning lot description and ownership statement, so it isn't clear whether DOB ever approved it, what its purpose was, or whether the project ever utilized it. The tax lot was never subdivided to reflect the zoning lot subdivision, so nonetheless, the zoning lot was subdivided, but not reflected by any kind of a tax lot number. Discussions with respect to the absurd result question, DOB claims Lot 138 isn't undevelopable because it can be acquired by adjacent lots 40 and 41. I think that's an absurd answer. Why would either adjoining lot want such a sliver? Is DOB saying that where there is no possibility of acquisition by an adjoining zoning lot, then such a subdivision would not be permissible? I don't understand the point of their statement about being able to be acquired by the adjoining properties. Owner says they could build a newsstand or a cafe on it, but I ask, why would the owner of Lot 138 ever sell or build on it, since any development on it would obstruct views and access to the entry lobby of its own development project on Lot 37? Both DOB's and owner's answers I found disingenuous, but the zoning resolution doesn't require sincerity when it comes to zoning lot formations. So insincere, disingenuous, nonetheless, there you go. Okay. Where was there legislative intent to allow such subdivisions that result in useless, unbuildable parcels, such as landlocked flags, or, as appellants suggest, removal of slivers of rear yards to avoid more stringent rear yard regulations on zoning district boundaries, thereby creating unbuildable landlocked slivers? Owner provided us with a copy of a draft DOB bulletin that considers the complexities of zoning lot formations and subdivisions. With respect to the assumption that a zoning lot has been formed under the B definition, it states that it would be considered a zoning lot if there were an interdependent use between the two zoning lots. Isn't the main entrance to the building and subject building an interdependent use? So I'm finding DOB speaking out of several sides, contradicting itself, and I'm finding that quite confusing, especially with respect to I know these memos about these bulletins have been in various forms of draft for probably 10 years, maybe 20, about how the zoning lot should be formed, and these almost never get officially issued because the land use bar says, no, you don't understand how it really works in the real world, and so they actually never get issued. So I couldn't tell, but I didn't find any papers to support it, whether we're being asked to opine on whether an inner court is bounded by a wall or walls, and a lot line or lines. I just note DOB says the language is clear that in this case, walls must always be read in the plural. I just question, it's not really before us because they didn't really opine on this. How does DOB treat open areas opening to lot lines that are neither side lot lines nor rear lot lines by definition? What is that thing? Appellant asks us to opine on whether the sliver law applies to the current configuration of the zoning lot. I do think that is before us because DOB answered their question in length. Had DOB just simply said, we never issued a ZRD1 on this, therefore we're not going to discuss it, it wouldn't be before us because we wouldn't have a final determination, but their counsel answered the question. So now I think the question is before us. So others can disagree, so we can talk about that. So with respect to the sliver rule of 23-692, it applies to a defined term street wall, which is defined as facing a street, and not specifically to a wall on a zoning lot that has a defined term street line. So how does this play out when it is the side of a building? And I don't have an answer to this question. These are mostly rhetorical or asking or searching. What if the lot did go all the way to the street line, but the walls were set back, as here, less than 100 feet? DOB and the owner asked that we read the text narrowly and literally with respect to a zoning lot's formation and dimensions, but to search around in other portions of the text for what is really meant by the term street wall when it is defined simply as the, quote, wall of a building facing the street. 23-692 states simply that in R10 districts, it applies to, quote, buildings with street walls less than 45 feet in width. So I'm confused by DOB and owner's arbitrary and selective analytical process. Either you search around for meaning, or you stay tight to the text and you stay within what the text says. DOB's reliance on section 23-692E's instruction as to width of a street wall being measured off of the street line is also unpersuasive, since street line as defined as a, quote, a lot line separating a street from other land, where the location of the other land is entirely vague, unknown, and the term lot line is not specified as being the lot line of the zoning lot on which the development is located, and is itself defined as, quote, a boundary of a zoning lot. So arguably could be someone else's boundary of someone else's zoning lot. And DOB's conclusion on page 10 of its submission that a, quote, street wall must sit on a zoning lot line which fronts on a street, i.e. a street line, is patently incorrect, since we all know that street walls are located at all kinds of places relative to the street. That's actually, when you're looking at aggregate width of street walls, they show you a picture of a structure where the street walls aren't on the street line. So that's just an incorrect statement. That city planning may not have had in mind a zoning lot that was separated from the street line by an intervening sliver lot when it crafted the sliver law is clearly because it didn't anticipate that anyone would do such a thing. The sliver law was actually instigated by, among others, the building known as the Vizcaya at 110 East 71st Street, a 16-story sliver tower constructed on top of an existing townhouse and set back approximately 30 feet from the street line. So actually, the sliver law really was intended to prevent a repeat of this idea where the street wall facing the street was nowhere near the street line. The 1983 CPC report actually refers to a, quote, front wall, and in light of the Vizcaya, fronting certainly means facing, because there was the Vizcaya, which was the evil it was trying to prevent. By way of comparison, wouldn't the sky exposure plane apply to a building set back from the street behind another zoning lot or behind another building on the same zoning lot, would this same shallow intervening zoning lot idea also obviate the requirement to comply with the maximum base height and the sky exposure plane, since there is no street line on the same zoning lot off of which to measure? So I'm curious, so when you are figuring out the sky exposure plane, you're supposed to take the street line, and then you rise to whatever the minimum or maximum base height is, then you set back 15 or 20 feet, depending, or 10 feet, depending on where you are, and then you rise from the street line at your sky exposure plane, and your building can't penetrate, right? So it's true, though, that, when the building is set back and the street line is over here, the collision with the sky exposure plane will take a long time, but for tall enough buildings, you will collide. So the question is, under this same concept, if you had an intervening parcel like this one, would you no longer have to apply the sky exposure plane relative to that street? And so that's questions, because how far do we take this analysis? And my understanding is that sky exposure plane gets applied wherever you look. We always see them showing the lines in drawings of the sky exposure plane, even though the tower is in the middle. We had that application for the school, right? The tower is in the middle, and the sky exposure plane starting out way over here and doing this, and the tower having to sort of move around because they didn't use the tower regs. Right, it's
Isn't
different
that
with the
because
tower.
the lot had frontage
It-
on
well,
both
but that's a
streets
question.
versus this?
Right, so, but that's a question. If it doesn't have frontage, if the tower is set behind another building, which sometimes happens, and intervening, we have an application, is it before us right now? I don't remember. Anyway, there's another application where there's a very, very large lot sandwich between two sets of other zoning lots. And it's an unusually deep lot, right? If the building that was in that center lot, zoning lot, rose and didn't qualify for tower regs, and it rose and the sky exposure plane penetrated, would it be allowed to keep going? There's no frontage in that case of that lot. There was a little, in fact, you know what it was? It was the example that was given to us by the owner
Yeah.
of something where they wanted to eliminate a little piece of the zoning lot, and then they just never did it. It's a different project that was built. I have a diagram of it here. So that's a question. Would that obviate the sky exposure plane where you really do have a penetration of it when measured from the street line? So I actually need more from all parties on why the sliver law wouldn't apply to the portion of the building located within the 22-foot wide section of the zoning lot, where that portion of the building's street wall is facing the street. I believe you could argue either that the 14-story and the 22-foot wide portion that extends north towards 88th Street violates the sliver law, or that it's part of the aggregate with the street walls, all of which face 88th Street and thus complies, because the instruction about how you measure street walls is they're doing this, you add them up, that's the aggregate width, and as long as it's more than 45 feet, you're good. So there's two, but one and what's the difference? Nothing really, because they all have intervening zoning lots, right? One doesn't have a building on it, but they all have intervening zoning lots. And as to the tower on a base regulations applying to the site, which is 23-651, it is clear that the regulations apply to the entire zoning lot, since that's what it says in 23-651. However, the instruction for the base is that 70% of the width of the street wall must be located within 8 feet of the street line. So the out parcel makes it impossible to comply with that requirement. And it isn't at all clear to me that you should nonetheless not have to comply with the base height requirements, although the purpose of compliance is undermined by the absence of the street wall on the street line. So it's not clear whether, even though you can't make it to that point that's 8 feet from the street line, should you still be required to have a base? Then you look at what's the purpose of the base height, which is to have a street wall. So then you say, I don't know what the purpose is, but that's very confusing, and the zoning resolution doesn't tell you what to do. What I find, though, rather cynical, and I think that's what the issue is from opposition, from the appellant side, is is that the main entrance to the building appears to be over Lot 138, although the garden, where you go through the garden, past the concierge and mail room, and to the elevators, and there's no concierge at all on the 3rd Avenue side. That actually looks like the place you'd go if you want to put your bicycle in storage, or package deliveries, or something. So it's actually, oddly, the service entrance appears to be on 3rd, whereas the private entrance is on 88th. And contrary to DOB's statement, the amended plans still show one route of egress through 88th Street. So I'm not sure if we didn't get the most recent plans, but that's the route we have. We have one going out to 3rd and one going to 88th. I found the transcript that was submitted on the preliminary injunction action hearing very helpful. So if you haven't had a chance to read it, it's actually a very well-informed judge who really knows, I believe it's her, land use law. The transcript points out the reality with respect to the zoning lot formations, that owner relied on DOB determinations at the highest levels and proceeded with their project accordingly to the point of near completion of the envelope. So with respect to the subdivision, whatever we decide here, I believe should be for prospective application and not retroactive, because you do have, without coming to for a variance, you do have extreme reliance with respect to that issue. Though the question of the sliver law and the base was never asked at the highest levels, right? While they were prior to construction moving along. Okay, sorry for taking so long.
No, these are interesting cases.
Yes, very.
So, as I reviewed the case, while I agree that the outcome of the subject zoning lot creation sets a poor land use policy, what is before us is not the policy implication, but if the zoning regulation was applied correctly. So with regards to the ownership, zoning resolution applies to the zoning lot, and therefore it can't include lot 138 into the zoning lot, even if it is under the same ownership. And in this case, it's under the same LLC, individuals, but they are two different zoning lots. And I don't think there is anywhere in the zoning resolution that says if you have same LLC, therefore it is one zoning lot. You could have same ownership, but the purpose of the zoning lot could be.
Isn't it different LLCs, but same underlying
Yes,
owners?
yes,
Sorry,
it's the
yes,
same,
I just
yes.
want to
Right, so
clarify.
that
Yes.
further, I was taking the worst case, but
Oh,
I'm saying,
okay.
in this case, you have two different LLCs, that just makes it even further separation of it, albeit at the end, if you connect the dots, it goes to the same person. And it reminds me of one of the cases we had heard, and I was in the minority in the decision with regards to the Robinson case, where, we had said that if an LLC had been formed of these two, then we would have, the issue of the zoning lot merger and all of, with the abutting lot would not have risen, and we would have allowed that to be a separate zoning lot. So I kind of take this in the same vein
Sorry,
as.
I didn't understand what you just said. Say that one more time.
So in the Robinson case, this is the Staten Island case where.
But they weren't owned by LLCs. they
No,
were
but we had,
privately
in
owned.
our hearing, we had said if they were a different zone, if it was an LLC, if these were LLC, we would have treated this as a separate zoning lot. And therefore, the issue of merging with the abutting lot, because it's under the same ownership, would not have come up. And this was in our discussions as we were talking about whether this should be merged with the abutting zoning lot. So,
Yeah, but I just want to clarify on that one, it wasn't about whether they were the same zoning lot, it was about whether they were held in common ownership. And we never opined on whether the zoning lot had been formed, because it wasn't necessary, because the text that was under contest there was about common ownership and not a zoning lot. That's the issue here. So we're looking at whether common ownership automatically creates a zoning lot, and permanently and automatically creates a zoning lot. That's actually the question before us, right? And so that's what you should focus
Right,
on,
and I
not
don't-
just simple common
And I
ownership.
don't believe in this case it does.
Yeah. Okay.
I don't believe it does. Now, with regards to the depth of the lot of 138 as an issue, as I was reviewing the documents, what I found interesting is that when DOB was asked for a determination regarding legal windows fronting the north wall facing East 88th Street, in the initial ZRD1, it had a 30-foot depth of the out parcel along 88th Street. DOB had approved the legal window since these windows would be fronting a 30-foot rear yard located behind a 30-foot deep out parcel. The concern that DOB had was more as to how much of a rear yard was being maintained from the legal window. And as long as it was 30 feet, those windows in the rear portion, I'm calling it rear portion, but that portion of the wall that's facing 88th Street could have legal lot line windows. So whether that, that rear yard got enlarged from 30 to 60 to whatever, and in the process, the intervening lot on 88 became less, didn't matter in terms of the way the building was being evaluated for zoning compliancy. So,
I'm confused.
Say it again?
Because when I'm thinking of that out parcel, it started off being really small and then
it
got
started out,
larger.
actually, if you look at the original ZRD1, it was much.
30 feet,
It was
yeah.
30
It was
feet.
30, then it
was
went
30,
to
then it became 4, and then
4,
it became
then 10.
Yeah.
So for DOB, it was irrelevant whether it was 30, 10, I mean, it did opine on 4 feet, and I'll talk to that later on, but it didn't matter. Their issue was you may need, the development parcel needed to have a 30-foot of rear yard in order for those windows fronting that 88th Street
To be legal.
to be legal. That's really what they were reviewing at.
But
And-
that wasn't, to be clear, that wasn't what the zoning examiner looked at. The zoning examiner, different from the other examiners, was confronted with the question, if I have windows facing the 30-foot rear yard of the development site, and then you see the drawing that has a 30-foot out parcel, we can't tell anything from the review by the zoning examiner whether that influenced the decision, because he doesn't say anything. He just says, you can treat this thing as a rear yard, the windows are looking upon a legal rear yard, therefore complies. So, but the DOB never actually opined on whether there never was a follow-up ZRD1 to ask, is it still good? The out parcel's only 4, right?
Okay.
Right, I think.
As to that question.
Fair enough. Yes, the question was not to DOB whether the depth can be 30, 10, or 4. The question for the ZRD was, can you have a legal lot line windows, provided you provide.
Not
Right,
legal
and as
lot
long
line.
as
No, no, no.
Sorry, not legal, legal rear yard window.
Yes.
Provided.
Right, and so as long as there was at least 30 feet
Right.
retained
Right.
in the development parcel, it didn't make a difference.
it didn't
And so-
make a
So
difference.
that was my question,
Yeah.
because
Right.
then as that out parcel becomes smaller,
It
it doesn't
doesn't
make a
matter.
difference.
It
Because
doesn't,
at
that's
least the
what I mean.
30 feet in the
Exactly.
first
Right.
iteration, it even got greater
Right, exactly. So it
for
didn't-
the development parcel.
For the development parcel.
Because
exactly.
as the lot 138 gets smaller, what remains in the big development parcel got larger.
No, actually, in the ZRD1 that had 30 plus 30, so there was 60 feet from the street line to the first legal light and air window, they modified the design where they decided to build into that 22-foot wide lot a little bit. So then you didn't have 30 plus 30, you didn't have 60 feet from those legal windows, you had what ultimately was 40 feet from those legal windows. So it reduced. But the 30 feet
But 30
from
feet,
the,
you have
at least
but
30.
30 feet from the lot line of the zoning lot
Right.
to the windows was retained.
Right.
But it didn't end up being 60 feet to the street line. So that's what
Right, oh,
modified.
right, but they still always had that
They
30
always
feet
retained the
they
30
needed.
feet. They
Right,
always had the
yeah.
30 feet, and whether the lot got larger or less, it always maintained minimum of 30 feet from the lot. And that's how also the street wall, and I would say to your question of the sky exposure planes, were all evaluated based on that. And I will go
Based
back
on
and
what
look-
that, sorry.
I mean, when they evaluated the ZRD1, the original ZRD1, the sky exposure plane, all of those, if it was applicable from the inner portion of the lot line, would have been evaluated from that 30-foot rear yard, right?
We don't know. So that's the point. That's my question, is, for one, this is a tower on a base, so you don't have a sky exposure plane.
Let's hold off on the tower on the base,
Right.
because the tower on the base is only applying from the 3rd Avenue frontage, not on the 88th Street
No.
frontage.
Tower on a base applies to the entirety of the zoning lot. That's what it says in the zoning resolution, that if you're using tower on a base, then the rule applies to the entire zoning lot. That's why you have to calculate your 40% tower, and then whatever that means, that the base applies to the entire zoning lot. I don't know what that means, right? So because it's an odd-shaped zoning lot, which wasn't anticipated, I don't know that the base has to cover everything, because there's also lot cover, I don't know if there's lot coverage regulations without looking
Well,
at them.
the way the rules are, the base cannot cover the entire, I mean, there's a percentage of the lot coverage it has to cover, and the
For the
requirement.
tower, not the base.
But the base has to cover a certain amount of floor area, right?
Yes.
It has to pack it. It's called the packing of the bulk. The whole
Right.
tower on the base was packing of the bulk. So
Right.
to allow to pack in as much of floor area below the height of 150 feet total. That was the rule of thumb, was to make sure you pack in as much of the floor area below the height of 150 feet, with a requirement that the base had certain percentage of the floor area, which could be residential, commercial, whatever, but again, provided you met all the requirements of the other zoning requirements in terms of the rear yard, in terms of the,
Right.
the lot line windows and all of those things. So it didn't require that the base go all the way to the end from one lot line to the other lot line. If you had legal windows, you couldn't then
No,
build to the lot line, right?
Right.
You had to then move it back and allow for the 30-foot or 20-foot if it was a commercial property, to allow for that window. So oftentimes you would have the base, which goes up to the height of 23 feet, and then it sets back where the residential buildings are, which is a double-loaded corridor, to allow for that base, even though it's a base. You have a 23-foot base, which 23-foot height, where you have the ground floor commercial use, and then in the front, while it's going up to the height of 60 feet or 6 stories, whichever is less, you have the apartment units, but that doesn't mean that entire base of 60 feet is going all the way to the back
No,
of the property. It is setting back, allowing for the legal lot line windows and the illegal light and air and other things. So 30-foot setback was allowed above the base. So in this case, even if it had a base that went up to the lot line, doesn't matter how far that residential building, in this case, the lot line would have been up to that 10 feet from that intervening lot. Anything that is above it would have to maintain a 30-foot of clearance in order to allow for legal lot line windows. Legal windows. I keep
Right,
calling
that's
it legal
that's a
lot line.
separate subject, but
So that's why I'm going
Yeah,
back
yeah.
to the argument that
Yeah.
therefore it does not require, the base has to cover the entirety of the zoning law. It does have to apply, abide by a lot of the other requirements. And in this case, you have the rear yard requirement. Now, the appellant makes the argument that a street wall is a wall or a portion of a wall, a portion of a wall of a building facing the street, and I would say the terms, all of these are defined terms, the street, the building, street, all of, the term facing is not a defined term. That's the only thing that is not defined in that. And since the portion of the building wall faces East 88th Street, it is therefore a street wall. So let's go back to all the definitions. Street is a defined term. Street line is a defined term. A street line is a lot line, which is also a defined term, separating the street from other land. And the lot line, which is a defined term, is where the lot line is a boundary of a zoning lot. Now, in this case, if in the particular subject case as we have it, we have a lot line which has a lot line coterminous with the lot 138. But if we were to include that intervening lot as part of the zoning lot, then that lot line moves to East 88th Street, and that becomes what we would call, per zoning regulation definition, front lot line. because it's fronting a street. And when that happens on such a lot line that fronts a street, a front lot line is where the lot line is separating from a street and other land. In this case, it's not a front lot line, it's just a lot line. So there is a distinction between a lot line and a front lot line. And in this case, the front lot line is that 138th Street lot, which has that 22-foot frontage. That's where the front line, and it is front lot line, and it is not part of the zoning law that is before us. So if we were to apply the sliver lot, if we were to apply all these requirements, the problem is this lot does not have a front lot line. It has a lot line. So the measurement of applying these rules will be different.
But it does have a front lot line. You're just saying it's on Third Avenue. It's not on 88th.
It's not on 88th.
Right,
Street.
so,
has
but
a
it
front
does
lot-
have a front lot
I agree with
line,
you.
yes.
It has a front lot line, and that is on Third Avenue, and on 87th Street, because it has a zoning law that fronts on 87th Street. Right,
not
the zoning law
called,
extends to 87th Street,
Oh,
right?
Oh, yeah,
But
okay.
not on 88th Street.
right.
So, and the other thing, going back to the fact that the 88th Street is used as an
So I just want to clarify definition. The definition of a front lot line is not a line that fronts the street. A front lot line is a street line.
Yeah, front
Okay.
lot line is where the lot line is separating the street from the other land, from other
So
land.
just because this is the legal analysis, right? A front lot line is a street line, which is a defined term.
Yeah.
Then you go to street line, and the street line is the line that separates other lots from the, I forget what I wrote there. Other lots from something. Street line is a lot line separating a street from other land.
Street is a lot line separating a street from other land.
Right, is a lot. So just to be clear about it, so this idea of fronting, it doesn't appear in any of these definitions. We're just either a street line, and the street line separates the street from other land, just to keep it really
Right.
clean.
But I do think it is important to distinguish between what is a lot line versus a front lot line. So it does make a distinction between a lot line that is abutting another lot versus a front lot line which is abutting a street.
Are we talking about whether the sliver law
Yeah,
applies?
yeah.
Because then aren't we talking about street wall,
Yes,
which is different?
But the street wall is,
A portion of a wall of a building facing
facing
a
the
street.
street.
right?
And that's what triggers 23-692,
But when you look
correct?
at the street wall, a street wall has to be against a street wall line, and the street wall line
What?
has to
No, no,
be
no.
front.
No. The question is, what triggers 23-692?
Right.
And that's whether or not there's a street wall, as defined as a portion of a wall of a building facing a street.
right.
And that's where we should
You need to be
talk
precise.
about the
yes.
conversation. Is there a street wall on 88th Street on Greater Lot 38? That's the question before us.
Right.
And my answer to that would be, since that is a lot line and it's not a front lot line,
Since what is a lot line?
the subject lot that's abutting lot 138.
Right, so we can clarify what that is. That's actually a rear lot line.
Right, and one can
Right.
argue, though, that you don't even go to lot lines. You talk about whether or not the street wall is fronting a street.
Right, that's
And you
what-
can then
yes.
argue that if there is an intervening tax lot
Facing.
that is between the subject lot and the street, then one can say there is no street wall on that side, because it's not fronting a street, there is another lot.
facing a-
Facing
facing.
a street, there is another lot.
Or.
Or
say
you
it-
could disagree,
Yeah.
either or, but I think that.
Correct, to be precise.
Right, that should be the conversation.
But the regulations of this applies based on a portion of the lot line that is fronting a street.
No,
In
the
the-
portion of the
streets.
front line, the lot line is irrelevant to facing the street. Street wall faces the street, lot line is either located on the street line which case is the front lot line? Or,
And
It's
which
any
in this
other
case
lot
is
something else?
Which it is not. And so had this been, if this is just a lot line, it does not, the rules of the requirements does not go with the lot line. It is with the front lot line, because all the setbacks,
You have
the
to
front
split-
lot setbacks, the front lot setback are different from rear lot setbacks. So you cannot therefore apply, the lot line setback that is going to apply in this case will not be the same as the front lot line setback. It would be similar to a rear lot line setback or a side lot line setback, but not a front lot
You
line
need to
setback.
tie it closer to the text. We need to get the instructions. What does the text tell us to do? It tells us, A, that a street wall is a wall facing the street. So now, we don't know what that means, because facing isn't a defined term. So where do we go with that, right? And so if you're suggesting is that we're looking in other sections of the zoning resolution?
No, I'm
then-
just looking at the definitions of how it applies. When you
Don't
have.
put your hand in front of you, because we're recording this.
So when you have a zoning lot with a front lot line, the height and setback requirements that will be applicable to a front lot line is very different from a height and setback requirement that would be required for a side lot line or a rear lot line.
So let's do something specific, because the base height is what we're talking about
Right.
for the base height regulations, as opposed to the sliver law, which is another discussion, right? But if you do the base height, so I'm at a building base regulations on a narrow street, that's the street itself, narrow street, less than 75 feet wide, beyond 125 feet from its intersection with a wide street, so that's not us. So, and then what else we have? On a wide street or within a narrow street within 125 feet of the intersection, that's this site. The street wall of the base, so what's a street wall? A street wall is a wall facing a street. That's what it says. The street wall of the base shall occupy the entire street, defined term, but we know what a street is, frontage of the zoning lot. What's frontage? We don't know, because it's not a defined term. You can guess what it means, but we don't know, it's not a defined term. So it needs to occupy the entire street frontage of the zoning lot, not occupied by existing buildings. At any height, at least 70% of the width of such street wall shall be located within 8 feet of the street line. So the street line, we know what that is. That's the line that separates the street from other land, right? So this site doesn't have its own street line, so you can say, is that it then? It doesn't have its own street line? Are we only talking about the street line relative to my zoning lot, or do we get to look at other street lines? The zoning resolution actually doesn't tell you that. So you could say, nah, it's logical that it should have to do with my zoning lot, but is there guidance? Do we know? And that's kind of, and asking those questions are not necessarily for us yet
Right.
to decide. It's for the teams to decide or to argue. And then it says, and then the remaining 30% of such street wall may be recessed beyond 8 feet of the street line to provide outer courts or balconies and so on. So the idea in this case that either it applies or it doesn't apply, because do we care about the street line of somebody else's zoning lot? I don't know. But in any event, it's impossible to comply with this because the intervening zoning law is 10 feet deep. How in the world can we set 8 feet, right? But should we be setting 10 feet? And then we have a problem because there's no legal light and air for the windows, right? But there would have been, had there been no intervening lot.
So the appellant is really saying that this zoning lot is improperly formed, or rather improperly divided, because they're trying to skirt the requirements for the tower on base and skirt the requirements for the sliver law, basically. And the owner's response is, this zoning lot 138 is a proper developable lot, and so therefore, none of those other requirements will apply to this lot because this lot has no street line on 88th.
Correct.
Right.
Those are the two arguments.
That's
it.
basically it.
Nutshell, right. And if we go to the sliver law, now I'm on the sliver law and its instruction, it says, and this is an interior lot with respect to 88th Street, it says for interior lots, which shall be treated as, a height equal to the width of the street on which such street walls front, or 100 feet, whichever is less is the maximum height, right? So again, the street walls are walls facing the street, which unfortunately the zoning resolution now switches to the word front, because it could have said on which such street walls face, then it would have been consistent with its own terminology. So here we have street walls that face 88th Street. Does the sliver law apply? Because it doesn't have anything to do with the street line. It doesn't mention the word street line in that instruction.
I agree with you there, but the question is, that 10 feet is a potentially developed lot. Let's say it did manage to form a zoning lot on the other side, and somehow amended the building envelope so that it came forward on that 10-foot piece. Then you're no longer having a street-facing wall, because there is a building in front of you.
So
Because
it's
if you-
intervening building.
Because there's an intervening building in potential. Because otherwise, if you don't consider that, then to me, every single lot would have front street walls on every frontage.
Right, well,
And
that's
that's,
what appellate is
right,
arguing.
and I don't think that that's
Right.
what was meant.
Mm-hmm.
And so I think just the fact that there is a 10-foot lot that has building potential means that that can't be a street wall on that 88th Street
It's-
side.
But
That
does it-
would be
does it-
my,
Does it really,
Wait,
It's
so
like-
does it really have building potential, considering the easements that run with that property? There are easements that are egress easements. Can you really build on top of that lot?
well,
I
now
think
there's
the
no
DOB
longer an egress requirement on that side, so it really
Right.
can free and clear
Right.
be joined up with the zoning lot on the other side.
But from what I understand, they still are planning on using that side for
It's
egress.
it's the rear
It's no
yard.
longer an easement required
Yeah,
for
it's not an
egress
easement
there.
requirement, but that portion of the 30 feet, that, or whatever the rear portion that they have, which abuts the 138, they can access that, and they can use that. And that, but that's not a mandatory easement requirement, which
no, but
No, we're
requires.
talking about
Design
the
of the-
10 feet
I
that
know,
were
but it does not
originally part of
require,
an
but what
easement
I'm getting to
agreement.
is that from there, it doesn't require, one has to exit from 88th Street, that exit requirement, fire exit requirements is being met.
No, no longer. At the beginning of the appeal, that lot was needed for egress. Then
but-
they rerouted
right.
stuff on their
That's what I'm
first
saying.
floor, so
It's not-
second means of egress is on Third Avenue.
But this is the disingenuous aspect that I was talking about. Okay, maybe DOB bought that there's somehow or other two legitimate means of egress, even though one of them is through an intervening use, which isn't allowed, as far as I can tell. There's a store through one of those egresses. But the other is actually the front door of the building, because, and we see a lot of these, there are a lot of really beautiful projects where you enter through a garden on the side street, but the main building is actually on the avenue. That's exactly what this is. So that little 10-foot lot is really the formal front door, and you enter through the lobby, that's where your concierge is, that's how you get to the elevator bank. So it's not true that it'll ever be built. It could be, for example, they could construct a little thing there that complies somehow, I'm not sure what the regulations are on that lot in terms of how much, I mean, it's a 10 FAR zone, so I'm not sure how much you can actually construct on that lot and following various setback requirements or lot coverage or whatever. I didn't look at that. But they could technically build a little structure that's like a lovely hangout place for this building, and you enter the lovely hangout place, you go into the open garden, because I've also seen that kind of thing, so you go in to go out to go in, and it would be sort of some kind of an easement. There has to be an easement if the lots are not held in common ownership, right? And under sort of strict construction, it is not held in common ownership because it's two LLCs, right? So you would need an easement to use that lot for just everybody in the building passing over in order to get to the lobby, even though DOB apparently no longer requires it for egress, so that easement that's recorded isn't necessary as to DOB, but it certainly is to the viability of this project, right? Otherwise,
And that's
no
a private,
entrance.
and that's a private agreement between lot 138 and the subject lot.
But that brings up my second question. Is there really a question to anyone on the board that this zoning, this subdivision that was created was purposely to undermine the sliver law?
But is that what's
That's not
before us?
relevant, though.
It is, though.
No,
I
I
believe
don't
that-
think intentions should be in this at all.
I don't believe
Well,
that the board
let's
should
let him
stand for.
finish his sentence.
I don't believe that the board should stand for a purposeful underminement of the zoning resolution. The sliver law was created to create for certain protections. This building that they're proposing is going to have the very things that the sliver law was intended to protect against. So just because they decided to create a certain scheme to no longer be fronting on 88th Street doesn't make that fictional reality an actual reality. And these very buildings were, the sliver law was legislated to protect against these very buildings.
Wait, let him finish
So,
his sentence, then you can
I think
finish.
that just that we're not, as a board, we're not stuck to rigid interpretation. When there's a certain reality, we can't just ignore it because of a rigid interpretation of the text.
I just wanted to say that when you're saying a purposeful way of skirting zoning, it's all a point of view. That's your point of view. It's the developer's point of view to use any tool in their toolbook to get the maximum that they can for their developable lot. So I think that when you're talking about purpose, you're kind of making a judgment call, and I'm not sure that we should be in the business of making judgment calls here on somebody's intent. That's what I'm saying. So I'm like, yes, we should be trying to interpret the zoning resolution and to see how it applies in different situations. But I don't know that we should be getting into a conversation of whether or not there's nefarious intent here.
Okay.
Because I think that kind of gets us away from what we should be doing. We should be reading the zoning resolution and trying to figure out what it's saying and then apply it to this lot and just make a statement like, has it been correctly interpreted here? Not whether or not, there's a loophole, and I think that they're really trying to find their way into this and utilize the loophole to get the best. Everybody does that every day. We all use any loophole. If the red light camera says you can only go 25 miles an hour, but we know that you could go 34 miles an hour and not trigger a ticket, we're going to exploit that loophole. We're going to go 34 miles an hour because we know we can get there faster and not get a ticket because we're not triggering the red light camera. There's loopholes everywhere.
Right.
So am I an evil person because I'm going to go 34 miles an hour? No.
But
This is human nature. That's what you do. You look for loopholes and you plow your way through the loophole, and if you can, great. And if you stop, oh well. But we shouldn't have judgment here with that. And so that's what I don't want to be involved with.
Okay, but we have to agree that the sliver law would not permit this type of building, right? And, do we agree with this type of proposal?
Sliver law, if the building was built fully to the
To
lot
that
line, wouldn't
If the
permit this
zoning lot
building.
extended
If the
to
zoning lot
that.
extended.
I
to that
simply,
street
let
lot.
him finish, I just want to hear
Yes.
one at a time
So
like
if
that.
we agree that, so there is law, there's a statute that protects against this very thing. So similarly, you may not get that red light, you may not get that ticket on the red light camera, but if there's an officer seeing you, you are going to get pulled over and get a ticket. We can't permit, just because people can get away with things, we can't permit the essence of the statute, the legislative intent, to just go to be skirted around.
If this intervening lot 138, was part of the zoning lot, sliver law will apply. In this case, it is not. And therefore, I will have difficulty making an argument that we should therefore apply sliver law in this case just because it is 10 feet from the street line. Had it been 30 feet, we may have questioned whether that sliver law should have been applied or not, because in a 30 feet, you can build a reasonable building on that. 10 feet also, you can build a reasonable building. You can build a nice commercial, space on that 30 feet. You could build an apartment building which fronts the street. We saw that in IFC. IFC is one of them where we have a pretty narrow frontage where an apartment building is being allowed with only frontage on the street and not in the rear. So it is possible to exercise that. Well, all I'm getting at is that the sliver law in this case will not apply. My read of the text is the sliver law in this case will not apply because you have an intervening zoning lot which is not part of the subject zoning lot. And is it going against the intent? But yes, but it's not before us.
Oh, but that is before us,
Then
actually.
if it's going
The
against-
question of whether intent is relevant is before us. So that's how I just want to clarify, like, how our purview, there are times where the text is super ambiguous, right? You don't know whether you're supposed to go left or right, or you don't know what to do. So then we need to look at that. This is classic formation in judicial analysis, where the text doesn't tell us left or right. Now we are alone there and we can't figure it out. So then you move to the legislature and you look at what the City Planning Commission said in their reports. And if that's not clear, because often they didn't say very much, then you look to newspaper articles, you look to see whether other legislatures have dealt with this subject, and you use that to try to figure out what in the world does this thing mean. So one question that is before us is the zoning resolution clear, right? If it's not clear, we can look at intent. There's also case law that says you don't do violence to the intent. Is this something where we think it rises to the occasion where you're doing violence to the intent? These are discussions to have. That's how statutory interpretation is looked at, right? Okay, so just to be clear about what our purview is.
I don't think it is.
You think it's clear? That's what.
It is clear in terms of what it is, for the zoning resolution.
Right, but we
Which
have to
is
use
clear.
discretion.
Yeah,
I'm
sorry, I just want to which is clear?
The way the zoning regulations have been applied for this building.
For which aspect? We talked about
With
three
regards to the sliver law,
things.
with regards to the street wall, the base, the town, the base, all of those. The way it has been applied on the subject zoning law has been done per the zoning resolution.
So you think the zoning resolution statement about those three subjects
very-
are clear,
yeah.
not open to
Not in my reading.
searching deeper into
And
text?
do you believe the legislative intent would have permitted this building at this project?
Let's take this one way. Let's say if this zoning lot, when we are talking about street wall, if this did about a 60-foot or a 30-foot lot, right? And it had and this building rose in the rear as it's proposing to, it wouldn't be before us, right? As of right, if there was, right? Why is this any different?
So that's not really answering my question. Do you believe that the sliver law, like the legislative intent behind the sliver law is met with this project?
Yes.
Or you believe
It doesn't require to meet the sliver.
And that's solely because
Because it's not
they
fronting a
subdivided
street.
a zoning lot and they created this
The zoning lot, as was approved by Department of Building, does not front a street, and therefore it does not need to meet the sliver law requirement or the street wall requirement of a tower on a base.
I personally believe that where we've been honored with discretion, and in that discretion, we have to preserve the intent of the zoning resolution. And in so doing, we're protecting the community and the neighbors from the very harms, because whether or not if it was the same zoning lot, if it was one zoning lot, or two zoning lots, the same building's gonna be created, and the same structure would be created. And the only difference is that and the harms, we'd all agree that if this was one zoning lot, it'd be subject to sliver law regulations. We'd all agree that. So the harm, because there's certain harms that the sliver law protects against, and we'd all agree on that. There's a reason why this regulation exists. So to now have this technicality and say, well, because of this technicality, these harms no longer exist, I don't believe that is I don't believe that that is our job. I believe that we have discretion, and I believe in that discretion, we have to preserve the intent, the legislation intent, and protect when it's we have to protect the people of New York or the owners. That's our job. We need that discretion. We can't just read the text and say, oh, well, you found a loophole or you found a way around it, so it's okay.
Okay, so did you want to add something? Commissioner Otley Brown?
You know what, in the interest of brevity?
Yeah, no,
can
so
we
I just wanted to make sure I'm not cutting anybody short.
No, you're not cutting
Okay.
me off. I personally would love to just hear the discussion tomorrow
Yes.
because clearly all of us see this differently to differing degrees.
Right.
And I don't think that we're supposed to come to a conclusion here, and
No.
we've got an entire calendar ahead
Yes,
of us.
thank
So
you. Thank
I
you
would
for
love to
managing
move
our
on.
time. It's 12:30, but I didn't hear anything from Commissioner
Just
Sheda.
one
so-
final point. Should we, like, look at the formation of the two zoning lots, the one that's fronting the East 88th Street and the other bigger zoning lot? Should we look at the legality of the formation process for these two
Well,
zoning
so
lots?
that's kind of what I was going through in my very long reading. I was talking about how the zoning lots have been formed, and I had questions for Department of Buildings because they make a statement that because the zoning lot was only 4 feet deep, it wasn't a valid, therefore the entire zoning lot was unpacked, because not a legitimate formation of a zoning lot, and I question that, because either the zoning lot can be any size it wants, or, and I don't see why it can't, and they're using the word contiguity. So there's a requirement that when you form a zoning lot, when you're merging several lots together, that there's contiguity of 10 feet. Contiguity means it touches by 10 feet. Contiguity doesn't mean it has to be 10 feet deep. I don't know where the 10 feet deep comes from, and they're importing that. So I think they instructed the developer to unpack this whole thing improperly, because there isn't anywhere in the zoning resolution that says it has to be 10 feet deep. What was wrong with 4 feet?
It has to be contiguous with another lot. In order to form a zoning lot, you must be contiguous with another lot for
For 10 feet.
10 feet,
linear
and
feet.
that's why they expanded it to 10 feet,
Yes.
to give us the possibility
But-
that it could
which
join
I
up on the
find-
other side.
Which I find interesting. It's like, it could be a standalone zoning lot, but this will, DOB was saying, well, in order for it to become a zoning lot for a possible merger with another,
I don't believe it's developable at its current size and depth unless it is joined up with another zoning lot.
well, it is
And I
within
believe
100
that's
feet.
the-
It's within 100 feet, so it doesn't require
Doesn't have a rear yard.
Doesn't have a rear yard, so you could build full lot line to lot line, a 10-foot building.
So, so that's the thing, that's the question before to DOB. Are you saying that if you don't believe you could build on this, then it's not allowed to be a zoning lot? Where does it say that in the text, right? So they're importing a lot of their own interpretation that they didn't make clear to us. Somehow, 4 feet wasn't good enough, 10 feet's good enough. Why is it good enough? Because what is a 10-foot deep structure anyway? And those kinds of things. So I would, with respect to the question of whether we dig deeper when, according to, and is the text clear, et cetera, that's something that the parties really need to discuss tomorrow and brief. Because that's where we're going to get case law from them and direction from prior BSA cases, et cetera, et cetera. These are their arguments to make on both sides, or on 3 sides, or however many sides there are. Okay, thank you, everybody, that was really interesting. Okay.
Zoning calendar, decision items, item number 19, 2016-4138BZ, 323-327 Avenue of the Americas, Manhattan.
Okay, so what we were waiting for in order to be able to make a decision here was a certificate of appropriateness from the Landmarks Commission, and what we got was a certificate of appropriateness without any drawings attached. And so that requires a lot of very conceptual thinking when you're reading along, and they say the window should be this, and the material should be cement board or whatever. And we didn't actually get the approved LPC drawings, and then they submitted a revised version 4D, but it doesn't tell us what, and it told that it was changed to conform to the LPC approval, but it doesn't come with elevations. And then we don't know what the changes were. So this is one of those situations where we cannot sit and look at these drawings and try to figure out what the changes were, because our directions were very, very specific on this project about the size of the lobbies, about the entrances, about the size of the units, the residential units, et cetera. So if there are substantive changes, or really any changes to the 4D, we need to know what they are. And of course, we need elevations, because that's the total project. So I was kind of confused by not getting a really good submission from them. And then we did have before open questions on the EAS. They submitted a new one on July 11th. It's fine, okay. So and there was a question at the prior hearing about whether the wrap and the shadow analysis had to be updated. Was that done? It was done, okay. Yes, okay. Oops. Okay. Any other comments on this one? No?
Item number 20, 174-14BZ, 820 East 182nd Street, AKA 2165 through 2175 Southern Boulevard, the Bronx.
Okay, so I think we finally have drawings and calculations that show compliance with the C1 signage regs, I hope. Everyone all right with the sign drawings? And they resubmitted the light spread diagram, which they actually redid, and it clearly looks like it was done with meter readings because of how fluid the lines are. And it shows the lighting levels at the property line are very low. The last submitted drawings aren't signed and sealed.
Yeah, I told him.
I know.
He might, I'll remind him again.
Okay, well, it has to be done, or I don't want to do another hearing on this, please, no. And so, but we all did, so we also got just this morning details on the planter box, which are actually prepared by a landscape architect, I'm astonished and delighted to say. So that's much better and encouraging. So we're going to need to assemble these drawings into one package, since the applicant just sort of handed them into us haphazardly, which is a total drag, but nonetheless. So one set, I just want to alert to where these might be found. One set was submitted on June 29th and another on July 10th. And then the planter box drawing, it looks like it was submitted this morning. So the site looks much better now. But I would I'd like the commissioners to opine on this. This has been a pretty painful hearing process, because it's just gone on and on and on and on with tiny little changes here and there done each time. And the site was in very bad condition when we started. So I'm wondering what people think about a short leash on this. You don't have to decide now, but worth discussing.
And the owner will be present.
Okay.
And shortly, what would you be recommending?
Well, normally these are extensions for 10, and I'm thinking maybe just 5, so that there's more time to check in, so that it doesn't have a chance to fall into ruin again.
2?
I don't know. So that's up for discussion. Think about that.
Maybe 2 years.
Okay.
Item number 21, 8915BZ, 92 Walworth Street, Brooklyn. We have a request for adjournment.
Yes.
Item number 22, 111, dash 15BZ, 98 Third Avenue, Brooklyn. There's an administrative adjournment.
Correct.
Item number 23, 2017, 192BZ, 5402, 5414 Fort Hamilton Parkway, Brooklyn.
Okay, so at the last hearing, the board expressed extreme concern that demand would far exceed supply with the proposed reduction in parking, and that there are inconsistent analyses associated with this project, where the EAS and the rezoning action determined demand based on 127 trips per 1,000 square feet, while the applicant is insisting that 47 trips per 1,000 is the right number. The recent submission argues that both the board and city planning have used the lower trip generation numbers on other projects, and that DOT's 127 per 1,000 square feet number is somehow suspect. Meanwhile, of course, we have seen 127 per 1,000 used as a standard in various EISs, and the board has consistently used that number where the use at the site is not known because the tenancy can change. The board has also allowed low trip generation numbers where a known user is relocating its own facilities, as opposed to creating a speculative development or expanding facilities where the same patients will travel between locations. In rare cases where the facilities are very small and the typology of use is known, such as a radiology suite, where equipment takes up most of the room in the facility and few patients are treated at a time, we allow the lower numbers to be our guide. But here, merely stating that 47 per 1,000 is the right number, while 127 per 1,000 is the wrong number, I didn't find helpful. The study that was connected in a 14,000 gross square foot facility isn't proof that the 47 per 1,000 number is the right one. It is one study for a much smaller site than the proposed, so the type of practices at the site could well be different and less trip intensive than the proposed. This is especially concerning since the rezoning EAS for the subject site assumed the higher number and traffic and parking were major concerns with that application. They also did a study of the Calco facility, which is closer in size to the proposed. It was conducted on the Tuesday before Christmas of 2016, and what they called a typical day in April was actually only 3 days after the end of Passover, and in Borough Park, right? So when people haven't quite returned to normal routines. So that might account for the significantly lower accumulation rates in that April study, which was much less than the Christmas study. A study aimed at determining, so there's an argument that lots of people are taking e-hail, e-taxi rides, but it seems to me that if you're actually going to make that argument, then you have to do that using questionnaires over an extended period, because just going in one day here, one day there isn't enough to really know how patients are using that. We often get these questionnaires as a way of establishing what the real demand rates are. So there, because I think they also make assumptions about the e-taxi use and assumptions about the willingness of poorer people to take really long walks from the subway. When you're pregnant and it's 10 blocks away, you're finding somebody to help you get to the doctor's office, I'm assuming, who has a car. So would parking in the subject facility be attended and free? That was another question. So that was, it used to be free at Calco, and I don't know if it is anymore. When I look at the Google Street View, there are no signs on the Calco parking garage that indicate that's parking for patients. It's clearly the doors of a parking garage, but that could easily be parking that's not available to the general public, and people could think that that's just for staff. And there's certainly nothing that indicates free parking. So we see that often on these kinds of cases where no one parks at the subject parking lot because it costs $5, street's free, or the municipal lot that's too far away is cheap, and so everyone's parking on the free street. And so that's not really a good determinant of whether demand is being satisfied on site. So I also want the board to note, because I looked this up in case they didn't, because I know everyone does all of this stuff, that the Calco site was the subject of a 2012 parking waiver request, and I knew Commissioner Otley Brown knew that. That began with an ask for a reduction to 118 spaces and ended in an approval of 177 spaces, or a reduction of only 25% rather than 50%. It's in the same community board as the subject site. In that case, the user was known. There were overlapping uses from a nearby facility, and studies of similar sites were also conducted that indicated even heavier usage than that based on the Institute of Traffic Engineers data standards. So that actually, once they did an actual study, they found out that the demand would be even higher. So it would be, and I have to say that for the BSA to be the one to decide that the new standard is 47 per 1,000, based on this kind of e-hail preponderance and so on, if indeed that's the case in neighborhoods like this, then I really would like to hear more from city planning and Department of Transportation, because they really are the purveyors of how EASs should be analyzed. Is the medical profession shifting in some way relative to demand? I know that the applicant's traffic consultant or transportation consultant reached out to AKRF and that kind of thing, but that's not really sufficient. I would want to see that city planning is now accepting in its EISs always 47 by 1,000, no matter what the proposed use is. Furthermore, I do have to say, we shouldn't ignore the concerns of so many area residents. We had a lot of opposition letters on this, and the preponderance of other community facilities in the area that impose demands on the street system also, or the fact that the site is so far away from the subway. So this is right smack in the middle, surrounded by schools, a church, synagogues, lots of other things that are actually street parking heavy. And with respect to project costs for the 4, 3, or 2 levels of cellars, this is not a variance application, so our concern should be focused on street parking impacts. Furthermore, while groundwater may not have been encountered with the initial borings to 35 feet, the project was designed initially with 1 cellar and 3 subcellars, and the rezoning approved that on the basis of parking supply meeting demand as described in the EAS and as required by zoning. The project team had to have known that 3 subcellars in a cellar is a costly foundation to build, whether or not it realized that groundwater was located at 45 feet. So the only delta to this is the discovery of groundwater at 45 feet. And meanwhile, they can't complain about construction costs for effectively 4 cellars, because that was the original plan, right? The chart provided shows that the 3-level parking would avoid reaching groundwater if 6 inches were shaved off of each level, or 1 level of SUV parking were eliminated, and/or if the first floor were elevated somewhat above grade, which some of which could be done. We also had a project before us a couple of years ago where a turntable system was used that was very efficient with extremely rapid throughput times. So the issue of the single mechanism being slower, or a system that doesn't require slabs at each level is confusing to me. It and other versions of automated parking would eliminate the need for the extra ceiling height now being used for each mechanism. I actually see so many sophisticated and efficient systems available today. I have a YouTube video we can watch about one that's really spectacular. And notably, there are no affidavits from the automated parking consultant stating that this is the only system that would work, because I'm sure the consultant is aware of these really wonderful systems. That some of the videos that I saw were of retaining, there's actually no slab at all. The mechanism travels through this corridor, and there can be more than 1 mechanism, and they rise and they bypass each other, and it's really pretty fantastic. And they swirl around and they insert the cars into a shelf. And I noticed that one of them has sort of tray-to-tray heights of 6.5 feet. So, for the SUV. So,
Well, it's really kind of interesting, because I was thinking to myself when I was looking at those approved plans that had the cellar floor to ceiling heights of 5'10", I was like, I can't imagine that DOB would have even approved that for people driving a car in. So in my brain was like, there had to have been some kind of mechanized system that
Right.
was in the works, that they were explaining, like, that's why we only need 5 foot 10 inches clearance, because I didn't ever see that in any kind of parking garage that I've ever been in, where I would drive the car in, or even if somebody else would drive it in with such a low, not even a 6 foot tall human could stand there. So I just thought maybe they were planning some kind of an automated system that did that kind of insert cars in slots kind of thing,
Yes.
which would justify having such a low floor to ceiling height. Yeah. So, I mean, which would make a lot of sense.
Right, so they are assuming now a mechanized system, but what they're saying is it's somehow not practical to use one mechanism. So one of the videos that I saw was one sort of hydraulic system that picks the car up, swivels around, travels down a track, puts the car in. It's just one mechanism, right? And they're saying they want to use a system that requires a mechanism at every floor. So the elevator takes the car to the slab, and then the car comes onto a track, the track slides around, it swivels, it puts it in. So it's a kind of, it's like, let's say, a less thrilling kind of a system, but every floor requires the mechanism, and that, because of the mechanism travels on a rail on the floor, then you need extra ceiling height, because the rail drops down into the floor, right? And that's the reason for that extra height. So, but it doesn't seem like, obviously, there are other mechanisms that don't require that at all. So, and the parking consultant never provides us an opinion that says for some reason that those systems that don't have any slabs in them, they're just trays for, I have an image of trays for 7 stories. Even more maybe. Yeah, 7 stories. So why couldn't that work? Well, this is only 4 stories, right? Or three decks of subcellar, where you could probably get a little more in without the slab and without that extra thickness for the mechanism on every floor.
So what would be wrong with saying to the applicant, either you provide comfort that e-hail is the way to go by giving us a week-long survey at Calco that shows that 50% of all visitors are using e-hail or whatever to
Right.
support your statement, or provide the amount of spaces for the demand that you've already talked about, and we don't care how you do it, whether
Right.
you're doing it with an automated system that's got 7 sets of tracks, or 2 sets of tracks, or 3. You want to be out of the water table, it's on you to figure out how to do it, but you got to provide this many spaces. Either or.
Right.
And then we
So I
can
take
kind
that-
of move this out.
Right. I take that one step further, because again, we don't have transportation planners on staff, right? City planning does. So what I would like them to do is show city planning that same study and see whether city planning's environmental review division would come to the conclusion that you persuaded them. Because, by the way, my big concern is that this was a rezoning action where the EAS on the rezoning was using 127 per thousand. So city planning liked that, felt comfortable that this was the right zoning district, felt comfortable that the project going forward would meet the demand and therefore not crowd the street system. So the idea that you have an environmental review and then you step back from it and say, well, we made a mistake, but at a different agency, I have a lot of problems with.
Right, though I do want to just say that for Calco, having been here, I remember it was a very contentious hearing, because the neighbors appeared all the time, and they talked about fire and brimstone happening in that neighborhood should this building be built. You won't be able to drive down the block, you won't be able to find a parking space for miles. I drive by that site a lot when I do field work, and I don't see the street system overwhelmed to the extent that they predicted. Not even a little bit. So the narrative being told to us by Mr. Habib's group that e-hail is now a greater part of the trip share, I'm inclined to believe. And I know that when Calco was approved, there really was no Uber Lyft
Right.
to be considered. However, now, 6 years later, there is, and I have to say that it is fairly cheap, and everybody's using it. So when I listen to Mr. Habib talk, it actually rings true to me, because even I, who owns a car, actually says, oh, I don't want to bother looking for a parking spot
Or
when,
lose my
when my
valuable parking
Uber is going to cost me $5 just to go 2 miles. I'm taking Uber, or $9. It's just worth not having the hassle of looking for a parking spot. So that's why, to me, if they could provide enough survey evidence that that is really the mode of choice for Calco, I'm inclined to say, okay.
Right, provided that the economic group is the same. So that's my problem with this. This is known to be, they submitted to us all this documentation that says this is the 9th poorest community in the city, right? So $9 for a poor person, that's a lot of money, right? So $9 to get to the doctor's office, that's a lot of money. And the assumption that they're reaching out to Medicaid to get reimbursed for their Uber or whatever, may not be correct, right?
However, though, I would say that e-hail has taken hold in a lot of diverse, poor communities precisely for its availability, where regular traditional yellow cabs were not available. And now, everybody has a phone, even the poorest of the poor, and everybody has an
Right, that's
app.
true.
And just the fact that you can get a cab coming to your neighborhood is really a boost. And so a lot more people from poorer neighborhoods are using the app than use street hails.
And in support, if you're in the poorest neighborhoods, the car ownership is a bit lower than in
Yes.
other areas. But I do support, I'd like to see something that shows that this is actually what's happening, that they don't need this level of parking before.
Right. You want to add them?
Yeah, during the last hearing, I asked them to submit the geotechnical report to see how conditions changed from what they thought they were and what they encountered during the excavation. The geotechnical report indicate that the groundwater should be encountered at 45 to 50 feet. Considering that, I don't think they got anything surprising during excavation. One of my questions was, last hearing, if they claimed that during excavation, they encountered higher groundwater than they anticipated per the geotechnical report. If the excavation has started, I believe the excavation support system should be in place. Usually for a project like this, we do not start excavation until the excavation support system, which is, as far as I understand, on this project, is a secant pile wall, is in place, is already installed. And once you install something like that, you cannot, if you install 50 feet deep secant pile wall, you cannot come back later and say, let's make it 60 feet deep. You have to install brand new one. You cannot, yes, you cannot pull it out and put another one, or you cannot dig through it and increase the embedment. So I see like some sort of contradiction here. In addition, I did look at the proposals they presented. That proposal in the very beginning was 1 cellar plus 3 subcellars. The excavation depth for this was 50 feet deep, below sidewalk, let's say. 55 feet, which is 5 feet below the groundwater per the geotechnical report. So I understand going with that proposal would give them some hard time because they have to dewater 5 feet of water. But the last proposal they want to go with, which by the way require about 50% parking waiver, is just 1 cellar and 2 subcellars. This proposal takes them to 15 feet above the groundwater level mentioned in the geotechnical report. So I wonder here, why you want to build 15 feet above the groundwater? You still could add 1 more subcellar, which let's say it's 10 feet deep, and that's going to take you even to either around the groundwater table or maybe even a couple of feet above that. So adding 1 more subcellar is still possible. I believe the issue on this side is not differences in condition between what was revealed during the subsurface investigation, the geotechnical investigation stage, and what they encountered during the excavation. I believe based on the plans they submitted, I did look at the plan for the secant pile wall, and usually when you put a secant pile wall. The main reason for this is to close the four sides of the site to prevent groundwater migration into the excavation. Looking at the plans they gave to us, I believe this is just a three-sided secant pile wall. And if they put something like that, and they were expecting this secant pile wall to curve groundwater, it's not gonna do it. And I believe this is the issue they encountered. It's not difference in condition between what they got during the investigation and what they got during the excavation.
It's a three-sided is that what you just said?
It's not four-sided. The site is not fully closed from all the four sides, according to the plans I looked at. If they have some, I did ask them, by the way, last hearing, to give us the plans for the excavation support and to give us the plans for the excavation, the construction dewatering. I got neither of them. I just got the geotechnical report. But I still believe that adding one more subcellar is very possible, and it's not gonna take him significantly below the groundwater table.
I just wanted to understand one question. You said the secant wall is on 3 sides and not on 4 sides, and that might be the reason why they're not able to hold the
Yes,
groundwater?
usually, if you have a site with groundwater and you wanna dig below the groundwater,
You have to have.
what you do is you close the 4 sides,
Okay.
and then you look at the material around the excavation. If the material around the excavation is permeable, let's say sand mixed with gravel like this side, what usually you do, you make the secant pile wall penetrate deep enough to kill the energy of the groundwater to like turn from underneath and go up. So you either send this to impermeable layer like rock or even clay, make sure that you socket this secant pile wall into something that's gonna close the path for the groundwater to get in.
Thank you.
But they didn't do that. They didn't even, as far as I understand, again, according to the plans I looked at, they are architectural plans. Based on these plans, the secant pile wall seemed to be installed in just 3 sides, not the 4 sides of the site.
Anybody else on this? Okay.
Item number 24, 2017-214BZ, 1459 East 24th Street, Brooklyn.
Okay. One issue that was open was the retention of existing material. Unless this is in a flood zone and the floor at grade is to be abandoned for living space and therefore deemed a cellar under the flood regulations, the cellar isn't floor area and the perimeter walls can't count toward retention. I believe this architect knows this after having appeared before this board dozens of times, yet nonetheless still calculates it that way, so the drawings have to be amended. The demo drawings calculate material to be demolished instead of retained, which is exactly the opposite of the instruction that was given by those drawings. So it's hard to work backwards when the retained walls aren't fully dimensioned. The architect should rerun the numbers based on perimeter walls to be retained on the perimeter. The demo drawing sample that I assume the architect has received a copy of probably several times has notes that indicate how joists will be handled and other kinds of demolition. These demo drawings should match those. They also need to add the note to the drawings that removal of existing material in excess of that shown on the approved plans voids the special permit. We commented at the last hearing that the house is tall compared to the neighbors and asked at the very least that the attic be pulled away from the perimeter at front and rear. I only see this done at the rear, and the plan is confusing at the attic level because the plan section shows no resolution of the walls, so we can't tell how it cuts back from the edge. No change at all was made in the front at that level, and which is we specifically requested. Any other comments?
I actually thought this was administratively adjourned. Am I wrong?
What?
No.
No?
No.
No.
I don't have them, maybe I missed it. I don't know.
No. There was a submission.
What's the submission?
I don't have the date. Let's go take a look, because
I
those
don't-
were your comments about pulling back from I thought the building was too tall, but you said, what if you pull back the attic? So take a look at the
I
submission.
will.
All right.
Item number 25, 2017-304BZ, 160 17th Street, Brooklyn.
We asked at the last hearing that the plans show the building fully sprinklered and with fire alarms, that fencing with the fire department access area be shown on the roof play areas, that the closed window condition and 35 dBA attenuation to achieve 45 dBA interior as indicated in the EAS be shown on the plans, and it wasn't unless there's plans that I didn't see. And the school, we also asked that the school grade levels be shown in the classrooms on the plans, unless this is a no homeroom type school where there aren't actually assigned grade levels for the classrooms. Plans were reconfigured to cure the rear yard obstruction issue, to separate the terrace areas between the ambulance service personnel and the school children, and to open the lobby a little bit. Circulation is still exceedingly tight at the lobby and second floor, and very wasteful with 4 egress corridors to the street at the first floor. I'm still, it's not that I sketched it, but it seems to me, and we talked about this, I don't really see why at least 2 corridors, egress corridors, can't be brought down to the cellar level with a single run of stairs that goes directly to the street. So using fire corridors and cellars is a pretty common way of addressing that. So you go all the way down to the cellar, you run across the cellar, and then you come up a staircase that just drops you right into the street. So in this case, they're all dropping you at grade level you run corridors, so there are 4 corridors in this building just to get to the front at the first floor. So that's really messing up the lobby. I don't know if it'll work, but I'd like to see them try that. The plans, let's see, a noise study of the play roof and terrace was conducted and concluded it would have no impact on surrounding uses, in part because it's very high. And then somehow, I guess it concluded that the distance from the lower level roof is too far from sensitive receptors. I hope they're right, because there is nothing like the pain of once built neighbors complaining about children. There is nothing as terrible as that. And eventually you end up putting up acoustical fencing and you didn't plan for it, and it costs you more money because the structure of the walls don't handle it. I really, really recommend you take that very seriously, and not just on the general analysis for EAS purposes, but on the reality that it's misery when the neighbors hate your school. There was also a late June submission to DEP and DOT on noise, air quality, E-designation, and backup traffic pedestrian data. I think we had DEP air quality sign-off and approval for E-designation for hazmat. Are we still waiting for DOT and maybe DOT, okay. And how about?
One more comment on Friday.
Okay. And then the noise sign-off from DEP?
Well, we got the initial noise sign off, but then we sent the new study there and we're
Waiting, okay. Okay. Any other?
I just had a question because I didn't get a chance to see. Didn't we get a new submission? Was it some kind of a replica of what we had previously? Because I thought I saw a new submission for this
Today?
case.
That was last week.
Yeah, I wasn't here, that's why I'm just
Oh,
asking.
right.
I saw from July 5th, so I was just wondering what changed, or was it just a resubmission of the other stuff?
I think it was an EAS that was submitted late. I
Okay.
think.
It was
Not-
materials for environmental review.
Yeah.
Okay,
Yeah,
that's
yeah,
all I
yeah.
said.
But I
Okay, good, then it's fine that I didn't get that.
Move on.
Uh-huh.
New cases on the zoning calendar, item number 1, 2017-20BZ, 550 Fifth Avenue, Brooklyn. It's a variance for PCE.
Right. We have proof of a service of initial application to officials and proof of notice of hearing to officials and neighbors. We don't have a community board recommendation, and we need that.
I reached out to them, they haven't gotten back.
Okay, we do have one letter in support. This is a legalization, as it says in the description on the top. We do have fire department sign off I'd like them to clarify the hours of operation. The statement of fact says it's both 24 hours and from 5 a.m. to 10 p.m., so those conflict. With respect to the A finding, we need to clarify whether this is a hardship as to the tenant PCE versus the owner. What specific costs would the owner entail to convert the space to conforming use? And would DOB consider the PCE as having grandfathered the commercial use in the space? That's a question I always have. So it's a special permit. Would it have been grandfathered as commercial? Like, could you argue with DOB that you had a non-conforming use and now I can switch to a more conforming commercial use that doesn't require a special permit? I just don't know what DOB thinks about our actions when the action gets abandoned, for example. If you hand back your variance, but it's always been a PCE, did you vest maybe in a commercial use? Because there was a change in zoning.
Right, and that actually was a question I had, because if this is a commercial condominium, did you strip them of their rights, their property rights, when
that's
you
so
rezoned it? Because this is a
interesting.
commercial condominium.
Right.
Oh, right.
So shouldn't it retain its commercial use?
Oh, that's so
a very good point.
interesting. So, yeah, that's very interesting. So then it makes it even a harder question for a variance, because it could be a retail space as opposed to a PCE versus a doctor's office, right?
Wait, just to flag, because I know there was conversation with, or I had a conversation with city planning. When they rezone, typically they'll look at what the uses are in the district they're trying to rezone, because they're not rezoning for the purpose of rendering things illegal.
Right.
This PCE was not a legal PCE at the time it was rezoned, so CPC didn't know that there was a PCE in this spot.
Oh, right. They didn't go for, no.
Right, but they should have known it was a commercial condo.
No, wait.
Commercial
They-
condo doesn't mean that, a PCE isn't a commercial use person.
No, wait, that's not correct. So
Prior
in,
court
the
grants on the site.
PCE obtained a 7336 in 2000,
Right.
when the C4-3A extended 200 feet from Fifth Avenue, and then that expired in 2010,
And then when there was a rezoning,
in 2013.
did they renew their PCE
So
permit
they,
between 2010
so they
and
didn't
2013?
renew, but that's still,
Wasn't illegal?
Right, but then it
That-
would have
that's
been
also-
a legal retail use,
Yeah.
though. And because once it's a legal
Yeah, it was a
condominium
legal, right.
unit, that's a commercial condominium unit, you can't strip it of its commercial
It's
nature.
always been commercial
Sure, but
on
there's a
that
commercial,
site.
it can be commercial without being a PCE is all I.
oh,
Right,
okay,
yes, yes.
that's
all
the
I'm
question. We're asking, did by it being a PCE subject to a special permit, not sort of invested with, as opposed to vest, invested with this character that's different from retaining the non-conforming commercial use?
Yes.
And the reason to ask that is because they're comparing the as of right as a medical office as opposed to just commercial space, right? And that's a problem for this variance
Right,
application.
because they could have retail here.
Right. So, and I just, and I'd also like, just to finish my, not many comments, we should have a plan that shows the permitted PCE area prior to the rezoning as compared to the proposed, and to clarify whether the zoning lot at the time could be treated as commercial in its entirety, since it looks like the dumbbell racks boxing area extend further than the 25 feet from the former district boundary line. So that would have been an error by BSA to allow that. So that's one of those questions about reliance and stuff like that. That's a question. Yeah, we've had this in other situations where the BSA unfortunately isn't looking carefully at where the district boundary line is, and that little boxing area is this tail that would just end up being, I don't know what. I actually don't know what. So the 2000 resolution reads as if it was a legalization, but it's not clear to me, so maybe it was legalizing this existing condition. And then other question, because the medical office, in spite of the fact that it's only a medical office, it rents like commercial offices, right? I'm wondering, isn't it problematic that the return is 5% when
that's often good enough for us, and that's what we decide is the minimum variance. So, take it away.
Me?
Yeah, why not?
Oh, okay. I actually found this confusing, and I was wondering to myself if, oh, okay, never mind, okay, now I'm remembering it. It's actually interesting, the way they did the financials, because it's valued as a commercial condominium, they valued it as if it was being used as a PCE already, but technically, because it was a legalization, shouldn't it be just valued as if it's a commercial condominium?
Yeah.
Then it's either technically built into a PCE or built into retail, because retail should be legal here. And technically, it's unfortunate for them, I don't believe there's much difference in the building of that, because both of those are really built out by the tenant.
Right.
And so then really what it is it's a question of income, relative income, and that's a market question. And so if it is a legal commercial condominium and you can't strip its legal status as commercial, even though it can't have a PCE, I don't see what the loss is here.
Yeah.
It's just a question of, oh, well, that tenant can no longer be here.
Right.
That could happen in a variety of places. We need to go attract another tenant.
Yes.
I
This
don't
is-
know, but that's the
yeah.
question. When I saw commercial condominium, that's what went through my mind, because rezoning doesn't make a commercial condominium all of a sudden have to be residential.
Right,
It's
right.
grandfathered.
Yes,
It was a commercial use.
that's what we're
Right.
saying. That's the question.
Yeah.
Is did somehow the PCE intervene and do something to it? But I don't think so. Because you're not allowed to have the PCE unless there's a commercial
Right.
zoning district, so they couldn't have even applied, right? And it did have a special permit, so it's not at one time, even if it expired, right?
So I would say we certainly need a little more information
Right.
about that, because
Yes.
that, to me, is key to the case. In which case, or key to the not case.
Right, yeah. Okay. Any other comments on this one?
Yeah, just two minor things on the statement of facts. In the statement of facts, it says strict application of the use requirements to the subject site results in practical hardship. For me, this is kind of like, they are saying that the application of the zoning requirements is a source of hardship. I don't think this is the language to put there.
Right.
I believe if they start the finding A with the second paragraph, that would be more convenient or maybe helpful to us to.
What do you mean that they start with the second paragraph?
The second paragraph says, renovating the PCE space to allow permitting use would be costly and infeasible. So if they start with that, not with presenting the strict application of the zoning requirements as a source of hardship, that would be more helpful to follow the reasoning why they are asking for the waiver. This
Well, they
is,
start off with being unique, so that's the first thing that they have to do, right? And then they say that the uniqueness causes a hardship that affects the viability of their property.
yeah, but what they are saying is strict application of use requirements to the subject site results in practical hardship.
That's quoting from the zoning resolution, right? So zoning resolution says 782.
No, this is not the code. The code is in bold, and then right below the code, it's their own language. Strict application of the use requirements to the subject site results in practical difficulties and unnecessary hardship that prevent the property owner from realizing a reasonable return, etc. So putting this up front, it gives an impression that what they are saying is if we follow the zoning regulations, this is a hardship for us.
Right.
What I'm saying is do not present it like that. If you start with the second paragraph, here we go, it make more sense.
Okay, so, but just to, so for the applicant whose representative is listening, right? It's the result of the unique physical conditions, practical difficulties, and unnecessary hardship that result, and that prevent you from complying strictly with the use or bulk provisions of the resolution.
Yes, it's,
So you're just saying it's reversed?
Yes.
Complying strictly is resulting in a hardship, is what you're saying. It should be that the hardship prevents you from complying strictly.
yes, exactly, yes.
Okay.
Yes.
Okay.
Similarly, for finding B, on the third line, again, the language doesn't make sense. It says, in contrast, the return on investment from a medical office use would be only 5% less than 6.6 minimum desirable. It shouldn't say only. It only is like, oh, it's just only 5% less, so it's not a big deal. But it should say it's 5% less. So it exaggerates the amount, not just make it like minor. Do you follow what I'm saying?
Yeah, we think we have a bigger issue with the return than whether they use the word only in a sentence. On the one hand, the proposed has a 6.5% return, but the as of right has, and we don't agree that that's the as of right, as a medical office, has a 5% return, and the 5% return in our cases is often our target. We're like, yay, you made it to 5%. Sometimes there are variances that only make it to 2%, and the applicant, which sounds strange, but the applicant says that's viable somehow, even though that's worse than your bank account kind of thing. So,
Well, we have had, when we've had a return like that seemed like it was reasonable, we have had the applicant then supplement that with background material that says that the going-in cap rate for that use is much higher, and so that 5% is the minimum. So that we would accept to flesh that out. But I think the bigger issue here is it a commercial condominium? If it's a commercial condominium, does it retain its use as a retail space? And if so, is this a hardship?
Yeah.
Or is this just you lost a tenant,
Can I ask
basically?
for this for clarity for the applicant? Would we want the OB to opine? Would we want,
yeah.
would we want the OB to opine on what the legal permitted use for that space would
If
be?
that helps them clarify, that's their technical approach. I mean, they're going to have to go to DOB and all that sort of stuff.
Because that changes the entire aspect.
Right. I mean,
It, not only that, it kind of impacts the uniqueness finding, because then you're
It's a commercial.
a commercial condominium who has to just get rid of one tenant,
yeah,
but you're still retaining your ability to have a clothing store,
right. Or
a restaurant, a bar, so
Yeah.
then it's more of it's not as much of a, oh my God, we have this incredible hardship that has
Right.
befallen us. We've lost the PCE, and now we have to put apartments or like a psychiatrist's office in.
Yeah. Any other? No? Okay.
Item number 2, 2017-246BZ, 6163 Crosby Street, Manhattan.
Okay, we have proof of service to officials and proof of notice of hearing to officials and neighbors. Community Board 2 recommends denial, stating that the 72-21 findings for uniqueness and hardship are not met. The applicant hasn't explained why it hasn't applied for a good faith marketing effort special permit from city planning under section 74-781. The marketing effort process is very simple. Their response was, we didn't, because we're before the BSA and we think we'll make the findings. That's not really a good answer. With respect to the A finding, location on a narrow street is not unique, nor is the absence of loading docks, nor is the 12-foot 6th floor to ceiling height. I don't see how the irregular depth of the lot drives the hardship.
If anything, the additional depth is an asset not enjoyed by the majority of 100-foot deep lots in the area. There are many other lots on Crosby without retail at ground floor, according to the uniqueness study. And I don't understand the study that shows 18 lots in the study area with floor plates at 25-foot wide and narrower that have residential and joint live work quarters for artists. This site already benefits from joint live work as of right. So I'm just asking, why is that a hardship? And why isn't that the combination that's used as our as of right also? So you've got retail on half, that's as of right, and joint live work in the rest of the building, or joint live work plus offices upstairs. I mean, the fact is that in Soho, joint live work is treated like residential. So unless there's been a shift in things going on, I'm not aware of a change in the market where you're not able to rent these joint live work units to just people. So rent them or sell them or whatever.
I have a problem with A.
Okay.
The jump off for me is you can't be both one building for the purpose of the narrowness factor and then two buildings for the purposes of the load-bearing wall factor. Like, you can't, you gotta pick one and stick with one thing. You can't be big and then also small.
Right.
As it suits you. It's kind of like self-created, like you're dancing across the self-created line over and over again.
And so we did have a case with actually a much larger building. I think it was in Hudson Square, not really sure. Or certainly, where the building was divided by this party wall. It was actually either built as two adjoining buildings, and it had this divided party wall, and one of the arguments was that it's so impractical because the party wall makes it impossible to really combine the space.
But this was built as two separate
Yes.
four-story buildings on two separate zoning lots that was
then
then merged
combined.
into one zoning lot / tax lot.
Yes.
And now we're saying, but our issue is our party, our party wall is too big. That's
Right.
self-created. This is two buildings.
Yes, right, that's true. So either you look at it as two buildings, or you look at it as one building, but you have to pick something.
Right, that's what I'm saying.
Right, and you also have to, so if we look at it, because what we do consistently is when there's two lots held in common ownership, we say, you have to show us that individually they wouldn't have made a viable return, and collectively they wouldn't have made a viable return. So the merger of those two into one common ownership / zoning lot hasn't changed the viability factor, right?
Right, but you can't say the merging of it has created the hardship.
Right.
That's
Yes.
the key here.
Right.
You can't say, well, we did all of that, and now it's pain. Like, now we're one building, but we can't break through this thick wall.
Right. Which, by the way, I think structurally, you could just put one killer of a steel beam and you could open the walls between much more. We do see that sometimes on fancy restaurants and so on like that, where you don't do it on the upper floors, but you do it on the lower one, and the weight's distributed much further, so there's much more. Or
Like a fixed transfer beam, but this could be done if the two peripheral walls are like strong enough to take the load
Yeah.
and eliminate the intermediate one.
Right.
But if
and
they are
then
not,
foundation work in the cellar, because the cellar isn't really an issue here.
Well, you also can't merge two lots into one and then say, well, now my lot depth is uneven.
Right.
It's like any argument that they're putting forth that has arisen from their merging the lot is problematic.
Right. Okay. Also, all right, so we need to clarify what is that the hardship is. And then also, the use group 6 on one side and not the other, forces, unless you return the north side to a conforming use, 2 narrow floor plates. That's kind of a choice, right? So they both could be joint live work. But that's another question. You merged it, like you said, And when there were two separate ones, each one suffered in its own way, one benefiting from grandfathering and the other one not. And it would have been a lot cleaner as an individual building, right? And then, also, there's an old tax map that they provided that appears to show this tax lot combined with one fronting on Lafayette. So, and that was quite a common phenomenon back then, where the two buildings were back to back and shared a common rear yard condition. So what happened to that? So maybe there was further subdivision that we don't know about. That needs to be explained. And based on the existing drawings, the 9-foot 6-inch extension at the south building is already in place. The statement of facts describes it as a proposed condition. Is that, I don't know whether it needs to be a legalization exactly, because it's allowed to extend the joint live work, I think. Maybe not, because the joint live work also has some rules about when it was built, when it was occupied, all that. So it might be a legalization. Also, the roofs at the rear of the rooftop addition are described as unoccupied. I don't find that credible because there's nice little terrace.
Right, there are openings.
Yeah, there are openings, that's for the super to clean the leaves off the roof in Soho. Also, why is the retail space remaining fully subdivided in the proposed? That also makes no sense to me, even if you didn't buy some very heavy-duty steel to make it more open. It's very common to have restaurants on either side of party walls in two separate tenement buildings, for example, super common. There's a statement also in the statement of facts about the, quote, relatively high occupancy count for retail and concerns about egress. I don't know what this is referring to. These are very small sites. They're never going to be able to get to 75 people in these spaces. Linkage between the two spaces would allow two means of egress, so I, again, don't understand that. And why isn't one of I made that mention already, why isn't one of the as-of rights the current allowable uses? The statement of facts also states that construction is already underway. So in that case, I always ask, then why do you need the variance? Because the variance assumes that you don't have a viable project without it. So what are you building? We had that experience on that 14th Street project. You can't do it. Why are you doing it? And for how long has the retail space at the north unit ground floor not been occupied by use group 6? So I'm curious whether it's been vacant long enough to have been abandoned. With respect to the construction cost, which I found to be very, very high for the scope of work, what is actually being done that would cause a $10 million construction cost? Why a new concrete floor with excavation? Why so much structural steel, et cetera, et cetera? I mean, if they're saying the building's in bad shape and needs to be brought up to some other level, is that our problem? They're not saying the building is obsolete. They're not saying the building is degraded and needs all of these things to bring it up to some sort of contemporary condition. If it's degraded because it was neglected, that's self-created, right?
Right, or is it that they have to strengthen the lower floors to support that new 5th floor? And if they do,
Yeah.
that shouldn't be driving the construction costs and the financials.
Right. Because I thought $10 million, it's a 40-something million dollar acquisition plus $10 million. Why would anybody do this? So, others?
I had two questions. One was, I still question the A finding, because there are 13 lots that were found not to be able to have ground floor retail, and that's a pretty large number, so I don't know where the uniqueness comes in. That's my first question. With regards to B, the price that they cited, the development cost for as of right and for proposed, it's negligible, and my question is why the difference in the cost between the as of right is so negligible, and when there's no change, actually, in the plan, if you look at it, the difference between the as of right and the proposed, there's not much of a difference. But there is a cost difference in the construction between the as of right and the proposed, and my question is why? When it's the same, pretty much all throughout, except for Actually,
really
there's-
different?
There isn't any difference.
In the
Just
development
use
costs are the same.
That's gonna be in it. That's
Right,
it.
so then why is the development cost different? Development cost should not be affected by the
I
use.
thought it's the same.
No, development cost is 4.1 million for as of right, as opposed to 4.2 for the proposed.
No.
No, the development
no.
costs are 42,169,000.
I'm-
It's a difference of $30,000.
Yeah,
That's
it's-
it.
Okay, so
It's the-
I would have wanted
It's
it
the
to be
difference in the
totally same.
uses, and maybe a little more steel, or I don't
Yeah.
actually know why
Well,
there's a
that's
difference in the
what-
uses at all.
But it's not enough to make it. It's a $30,000
yeah,
okay,
difference
right.
on a
Okay,
four.
fine.
The bigger issue is the site value. It's overvalued.
Yeah.
It's, what it is it's based on building sales, and then on top of it, they're adding in the total available FAR that you could build it
Oh.
at. And when you're doing building sales and you have like buildings, you're drilling down to a price per square foot of building. You then apply it to the building you have, not to the building potential. Then, once you get your site value based on the building you have, then you use your construction costs to build up to what you want. And they're not doing that. They've got a site value that's based on other sales of mid-sized loft buildings that are 5 to 6 stories, and they adjust the comps appropriately. But then, on top of that, they're then applying that price per square foot to the proposed amount of space, including the extra floor. And then they're adding in construction costs to build that extra floor. So that's double counting that extra 4,000 square feet.
Right.
First in existing building and then to build it.
Right, okay.
But I think their biggest issue is their uniqueness.
Well, in addition to which, this is in a historic district, the maximum potential is the little rooftop addition they just got approved for from LPC. I don't care if you have 10 FAR, you can't build it here. So, other comments?
Yeah, the construction cost is kind of like very tough to follow, no details at all. I see that shoring and bracing are kind of like $400,000. According to the number, the square footage they provided, it sounds like they need to shore the entire building from like the lowest floor to the highest floor. I don't know why they need to do that. Excavation and demolition, I believe the first and the second item are like repeated. In the first one, it says remove slab and excavate for new floor
Right.
footings. It's 5,000 square foot. And then immediately after that is excavate for new floor and dispose of site. It's 204 cubic yard. So I believe it's duplicate.
Right.
And the structural steel is calculated based on square footage. I don't know why they did that. They should calculate it based on tonnage. They give us the tonnage and the unit price per ton. Instead, they got it based on square footage. So,
Wouldn't it even be linear foot, not square feet? Structural steel, it's by
it's
less.
structural steel, usually you go to beam by beam, column by column, and you add the linear footage times the weight per linear foot. Then you get the total weight, and then you add this up to get the tonnage at the end.
Right. But for us to see tonnage wouldn't be that informative, but to see linear feet would be informative, and then you can derive the number by multiplying by tonnage.
Yes, they could
Right.
either provide us with plans with linear footage for each structural element, or they could have the structural engineer give them like a flat rate. This is, let's say, 10 pounds per square foot. So what they do is they take the square footage for each floor, and they factor this times 10 pounds. They give them the entire tonnage in pound, and then they convert this to ton.
But I don't know why they need structural steel in this building, other than for the addition at the rear, the addition on the roof, and maybe to span the opening, which they're not doing, but anyway, to span the opening with the party walls. So what's all the steel for? Are they gutting this building and that they're including that in
It
this?
doesn't sound to be the case, that the total square footage for the structural steel is way higher than that. It's 81,000 square footage. I don't know what is that.
That's the thing.
That's-
So
that's why I'm
what in
saying-
the world are they doing? It sounds like gutting it and putting steel beams throughout the building, et cetera, et
That's
cetera.
why maybe they are like bracing the entire building. Maybe they are strengthening the entire building structure.
And, is that something that should be figured into an analysis for a variance when you've got a historic property that was occupied by tenants up until they sold out their co-op, right? So the idea that the developer goes in and guts the building sounds more like an option as opposed to a requirement, right? Especially these 19th century buildings where it's old wood members that are really, maybe they need a little reinforcing, but it doesn't need to be gutted.
But if this is associated with the proposed use, wouldn't this be like a self-created hardship again because of the use proposed?
Sure.
They need to strengthen the building.
Yeah,
So-
yeah, sure. And if it's associated with adding, as Commissioner Otley Brown said, adding the rooftop penthouse, which covers the entire thing, absolutely, yes. Right, so,
Can I go back to Commissioner Shetter's? If the proposed use was being done without the additional rooftop, then if the proposed uses are being done,
The only reason I can see as a structural engineer for doing that kind of work is that the building could be in its current condition.
needs brace.
It needs strengthening, or it's
Right.
structurally unsafe. That's why
Right.
they are doing this bracing from floor one to
Right.
the highest floor.
right.
Even sometimes, if you're adding one floor on top of a building, if the walls or the columns can take the loads, the only floor that you need to strengthen is the very top, because its past use should be like a roof, and now you're gonna put life load on top of that. So you need to put some sort of strengthening to that specific
Just for
floor.
that, you don't need it for the.
You don't need it for the rest, unless the building, and like I said.
Itself is in need of it.
It needs strengthening
That's what I'm
regardless.
getting at.
Yeah, yeah.
Thank you.
Okay. Anything else?
Nope, we need construction cost estimate.
Yeah. Well, we do have a construction cost estimate, so we'll talk tomorrow if we need additional information, but they do need to get past this A finding before they dig into cost estimates, right? We have a problem with A, and there's an approach issue with B before we ask a cost estimator to sit there with a ruler and drawings and all that stuff, okay? Commissioner Shabeta, do you have comment?
I have nothing to add.
Item number 3, 2017-300 BZ, 1275 Woodrow Road, Staten Island. The city
Hey, this is a,
PCE.
I'm sorry. This is a legalization of PCE, which opened in June of 2017. We have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board recommends approval. We have one letter of support, DOI signed off. There is a statement from the sprinkler installer that the systems are installed and operational. There's a fire department letter of approval for the fire alarm system, and I just want to make sure fire department is otherwise okay. They seem to be okay. There's a thumbs up in the audience. However, it's never just simple like that. This is a 178-foot deep split lot under a very confusingly described zoning district designation, putting what I believe is, and it really needs to be verified with city planning because it's such a weird zoning map, what I believe is 100 feet of the lot in a C2-2 overlay and 78 feet in a C1-2 overlay. This special permit is not available in the C1-2, so the drawings have to be clear that the PCE does not extend into it, and that's not my impression from looking at the drawings, because you have the building is set very far back on the lot, and then there's a parking lot behind it, and I actually think this falls in beyond the 100-foot point, though the drawings don't tell us anything. I'm getting that from tax maps and Google Maps and things like that. So what I would recommend the owner does is, or owner's representative, is contact city planning and find out what they really meant by the depth of that zoning overlay, because there's this 100 number that's sort of floating on the zoning map. And I don't know if it applies to the depth of this, or if it's applying to the depth of, there's something called the former SSL of Spar Avenue. I don't know why that would be relevant on a zoning map, but anyway, so there's a dimension that's floating and I don't get it. So
Well, from the scale of it, it definitely,
it looks like it's 100-foot
Yeah.
overlap. But I just want to make sure, like, even if it's 125 feet and it's one of those cases where it's 125, that would help the site, whether or not it cures the problem, I have no idea. So it's kind of an uh-oh application, or not kind of, it is an uh-oh application. Anybody else on this? Good catch.
okay.
This concludes, no, I don't know if you were finished, anyone
Yeah.
speaking, okay. This concludes the public review session for July 16, 2018.
It does.